on. Okay, so now that is working.
I didn't test my sound because there's sometimes issues with my sound.
But it should be fine. It's bouncing, so it should be fine. Yeah. Oh, the image, the actual image. Oh yeah, it's there. It's right now.
Perfect.
Okay, I'm gonna start stuff on that.
Should I switch that?
So which one you gonna do?
Good morning, colleagues, distinguished guests, and delegates attending both in person and online. It is my honor and privilege to warmly welcome you to this important alternative dispute resolution seminar hosted by the School of Law at the University of KwaZulu-Natal. I do so on behalf of the Deputy Vice Chancellor of the College of Law and Management Studies, Professor Kalema, and the Dean and Head of School of Law, Professor Imyongani, both of whom extend their best wishes for a fruitful and engaging session. This year's theme, formalizing online dispute resolution and alternative dispute resolution mechanisms within the African regional communities, speaks directly to the future of legal practice on our continent and beyond. In a world marked by rapid digital transformation and the urgent need for accessible justice, the formalization of ODR and ADR systems is not just a progressive step, it is a necessary one. Today's program, ladies and gentlemen, promises to engage us on several critical points and on several critical fronts. We begin with a focus on the African continental free trade area and its dispute resolution protocols, where we will explore the legal and institutional infrastructure needed to ensure cross-border commercial justice. These discussions are particularly valid as we reflect on how ADR can support regional economic integration in Africa. We then shift to family law mediation, with presentations that consider the role of artificial intelligence in family law, the integration of ADR in customary court systems, and even mediation within the context of assisted reproductive technologies. These presentations, ladies and gentlemen, highlight the versatility of ADR tools in addressing deeply personal, often emotionally charged disputes while promoting dignity and fairness. In our final session, we will delve into ADR's growing impact in the consumer protection landscape and within the company's tribunal, where legal compliance, accessibility, and efficiency are essential for resolving disputes outside the courtroom. Together, these sessions reflect the evolving legal terrain, one in which dispute resolution is moving beyond traditional litigation into collaborative, flexible, and increasingly digital spaces. As legal academics and practitioners, it is incumbent upon us to integrate these developments and to consider how to best to integrate them into legal education, legal policy, and professional practice. UKZN is proud to be at the forefront of these discussions. We hope that today's seminar not only sparks critical insights, but also encourages partnerships that will help shape a justice system that is more inclusive, responsive, and fit for the 21st century. Thank you once again for joining us. I wish all of you a thought-provoking and enriching seminar. I will now hand over to my colleague, Dr. Simpiwe Pungula, who will make some opening remarks. Thank you, Dr. Pungula.
Thank you, Professor Subramanian. Good morning, colleagues. Good morning to everyone who's attending the seminar. Am I audible? Thank you so much. Thank you so much. Good morning, colleagues. I would like to greet everyone who is attending the seminar, talking to the legal practitioners, the academics, students who would be attending, and everyone who is interested in ADRs. I would like to open this session by stating that access to courts is a constitutional right, but access to justice is actually a concept that goes beyond the availability of court processes. This concept refers to different methods by which an individual may obtain legal assistance. Now, ADR is one of those methods. ADR is an increasingly important and expanding alternative mechanism to provide justice. As we are going to see from our presenters that ADR touches on several aspects of the law. We are talking about commerce or commercial law. We are talking about family law. We are talking about any other law that has some disputes in it. And then ADRs are there to try and deal with the process of mediating any problems or any dispute that individuals may face while they are actually practicing the law, if I may say. So therefore, in my view, if we actually look at ADRs, we can actually say that ADRs, or rather ADR, is a tool to administer justice, and it needs to ensure, rather it ensures an effective administration of justice. Why? Because if one is to actually look at ADRs, you can actually determine that ADRs are, for example, faster. Why am I saying that? This is because if one were to actually look at the court system, the court system, especially in South Africa, is overloaded. It can actually not hold a trial of every lawsuit that goes or that gets filed. Therefore, with the ADRs, as a result of the ADR, it is actually simpler and faster to resolve the disputes and the issues that people face on day-by-day basis. So that is why I'm actually of the view that ADRs, of course, we do have access to court as a constitutional right, but ADR actually plays a more role in access to justice, whereby one person needs to access to justice rather than access to the courts. And as I say, my submission here is that then ADRs are actually faster to try and administer access to justice for an individual. It may be, as I'm saying to you, as we are going to see on the presentation, it may be a dispute between individuals, or it may be a dispute between companies. It may be a dispute between a company and a natural person, or it may be a dispute in a global perspective of it. I see that in some of the presentations here, we are going to be talking about a free trade, which actually means that we are actually connecting Africa and the world at large, and how ADRs play an important role in fostering that economic growth. Because at the end of the day, the idea is that when it comes to ADR, you are trying to resolve any disputes in an amicable manner and in a faster manner. By actually doing that, it means that one is actually trying to mediate so that there's also going to be an economic growth within a region. If it may be between South Africa and another country, then it means that there's a growth between those countries and the relationship itself between the countries. Because once you actually have that relationship between countries in terms of, for example, free trade, then one can actually conclude that indeed there is going to have to be a common economic growth within that region or at a global stage. Secondly, if one is to actually look at ADR, or alternative dispute resolutions, one can also see or conclude that it has lower cost as compared to a normal trial. Why? Because when you actually look at the ADRs themselves, you can actually tell that they are cheaper than a trial. Just a discovery process for going to a trial can lead into an enormous cost or legal cost that includes attorney's fees, it includes expenses associated with printing and mailing documents, etc., etc. But when it comes to ADRs can just be a process whereby individuals meet and mediate the matter without going to court, which means that one cannot actually incur legal costs that would actually be similar to those costs whereby one uses the courts to actually resolve a dispute between the parties. So in other words, ADRs are just there as a tool that is actually flexible, and that is actually more conducive in terms of the legal costs that one can incur if they want to actually access justice in a specific matter. So ADRs are actually there to deal with those issues. And as I said to you, because of the fact that ADRs have lower cost, then it also goes to the flexibility in that the ADRs are less rigid as compared to court proceedings. Unlike a trial date that can actually vary because of the backlog, ADRs can actually be scheduled at any time, as long as there's a dispute and people that are in that dispute consent to an ADR. It means that that ADR hearing or that mediation can be scheduled at any time. So this actually then creates a flexibility, and it helps to speed up the resolution of that conflict. And as we are going to see in the presentations that are going to be done today, we are also seeing an increase in AI, if I may say, or in online dispute resolutions. We are actually now looking at technology, on how technology can be used to deal with the with the mediation and resolving disputes between the parties. And most of our presenters here will actually be dealing with online dispute resolutions, whereby internet is actually used to deal with online dispute resolutions. But what is also more important about ADRs, if one is actually looking at the presenters or the presentations that are going to be actually dealt with today, you can see that ADRs are not only for commerce, but they are also for family disputes. I see here that we are going to have some presentations on family law mediation. So therefore, it means that when it comes to ADRs, it's not only about commerce, it's not only about trying to grow economy within the region or within the country or within the global perspective, but it also touches on the issues that are domestic between the families themselves. Therefore, ADR, in my view, is that type of a mechanism that is there to deal with any dispute in a faster manner, in a flexible manner, without incurring legal costs by those that are going to be in that dispute or that are in the dispute. Therefore, in my view, by the end of today, we are going to see how ADRs are used to resolve the matters that are in dispute in terms of commerce, that are in dispute in terms of domestic disputes. And as a result of that, I welcome all of you to the presentation, and I'm looking forward to see what are the issues that are there in relation to ADRs and how we can move forward and resolve some of the problems that are faced within the ADR process itself, and moving forward. And with those words, I welcome everyone to the seminar, and I'm hoping that by the end of today, we are going to have a clear picture on how ADRs are actually conducted, either commercially or in family law disputes. And as a result of that, welcome everyone. I'm looking forward to hear the presentations. I'm looking forward to engage with everyone on the issues that are going to be discussed, and I'm going forward. With those words, I welcome all, and thank you so much, Professor Subramanian.
Good morning, ladies and gentlemen, and welcome to this webinar on the online dispute resolution, alternative dispute resolution. Thank you, Dr. Simpiwe Fungula, for your statements and your remarks on the need and the necessity for us to have a look at the ADR mechanisms, ODR mechanisms currently in place, but also what we need to do, not only within South Africa, but of course looking at the broader perspective of what is needed on the African continent. And I cannot emphasize that more enough. Ladies and gentlemen, at this particular point, I just want to take you back to where we came up with this idea of the ADR ODR webinar. Last year, we started with the ADR RIG. RIG is a research interest group. And our Professor Subramanian started this initiative to form this research interest group and bring together staff within our school, of course, who have this particular interest in the in ADR, ODR. My particular interest was to not only frame it within the South African context, but to take it outside and look at the impact that this can have at the regional level. SADC, the Southern African Development Community, COMESA, ECOWAS, and so forth. And for us to look at, but how can we strengthen first of all, what are the mechanisms that we currently have in place, and how can we strengthen those mechanisms if indeed we are to achieve the vision, the mission, the goals of the African-Continental Free Trade Area Agreement. Having said that, we sought to want to extend this discussion to this webinar and to share our ideas and start looking at how we can strengthen, how we can further the ideas that is vested within AFTA, but also within our own national context and so forth. Of course, AFTA provides us with an opportunity as a continent to form the Africa that we want, and it is aligned with Agenda 2063. And I'm specifically mentioning that because we tend to forget in South Africa that we are part of a continent, we are part of a region, and how we can work with in the SADC, COMESA, or the ECOWAS as a means to strengthen the regional framework. Way back in 2018, the African Union delegates approved a declaration to launch the agreement establishing the African Continental Free Trade Area and, of course, the AFTA agreement. But it also meant that it launched the Protocol on Trade in Goods and its associated annexes, the Protocol on Trade in Services and its annexes, and of course, the crux of our focus today, which is the Protocol on Rules and Procedures on the Settlement of Disputes. AFTA, the largest free trade area, is the flagship project of the African Union's Agenda 2063. And as something that we need to emphasize when we speak of AFTA and the opportunity that it brings for us as South Africa, Southern Africa, and especially for the African region. It is regarded as being too big, too ambitious, and that African countries and the African Union seem to have forgotten the particular challenges that impede and that pose a barrier to trade within the African region. Notwithstanding that, it draws together members of different levels of development, mostly your developing and your least developed African countries, regional economic communities, which I have said have various challenges from infrastructure, lack of infrastructure development, particular frameworks, etc. Many obstacles to establishing the Africa that we want, and creating that particular frame for us to operate and to ensure economic growth and reduce poverty. If we analyze the AFTA agreement itself, it recognizes those particular challenges that African countries face. It is mindful of existing agreements, existing regional economic frameworks that are there to emphasize, that have established frameworks, but it's looking at how can we strengthen, as I said at the beginning, this particular framework. And Article 3 and Article 4, which deals with the general objectives and the specific objectives after, which are, of course, both provisions are mutually reinforcing, emphasizes once again, and I've taken some of those objectives, that we aim to, and I say it's we because it's focusing on African countries, and our commitment to working together collectively deal with those particular challenges that face internal trade. Let's strengthen internal trade to enable external trade. So ultimately, if we summarize these objectives, they're focused on eliminating trade barriers, boosting inter-African trade, foster sustainable and inclusive socioeconomic development, gender equality and structural transformation, enhance the competitiveness of the economies of the state parties within the continent and globally in terms of Article 3F, and ultimately resolve the challenges that are hampering regional and continental integration processes. It's interesting that, and as I've mentioned previously, that the drafters of AFTA are quite aware of those particular challenges, and many authors have highlighted the effect of these challenges on African countries, where we see overlapping membership, different levels of development, in such a way that the multilateral system is unable to really deal with or enable African countries' participation. I'm not putting the WTO as aside the World Trade Organization, because the AFTA agreement, in fact, recognizes the WTO in its instruments. The dispute settlement, the protocol on rules and procedures on dispute settlements, in fact, is built on the WTO dispute settlement process and so forth. Ultimately, if we look at this particular discussion of ours, it is focused on actualizing internal, external trade relations, and of course, seeking to coordinate African trade better. And for that, the AFTA, in terms of Article 20, provides that a dispute settlement mechanism is hereby established and shall apply to the settlement of dispute arising between the state parties. However, the substantive provisions are outlined, as we've mentioned, in the protocol on rules and procedures on the settlement of disputes. This particular protocol aims to ensure transparency, accountability, fairness, and a predictable dispute settlement. Basic aims that are also emphasized within the WTO dispute settlement. With a focus on our theme, Article 8 of the protocol outlines the good offices, conciliation, and mediation. Having now given you this background, we sincerely hope that this is not going to be the only time that we discuss ODR or ADR within this particular context, but that we have a broader idea of how to extend it, and that we understand and actualize these particular mechanisms, not only for the South African purpose, but for the African purpose. We are facing several challenges now within the multilateral trading system, as well as in the bilateral trade, which is indeed a concern for African least developed countries and for African developing countries, my apologies. We need to look towards, as was emphasized previously, internally as to what we can do, how we can address those particular measures. If we are going to participate, if we are going to be able to participate at the continental level or at the multilateral stage. It is for this reason that this particular seminar addresses those particular issues, but also brings us to the practical challenges that are faced within the labor law discipline within family law disputes and within the commercial disputes, but still within the broader frame of the African continental free trade. And we are pleased to have our presenters who will shortly be joining us after our tea break to present their views on these different areas and to identify for us what we can do within the South African space, but also within the regional and the sub-regional spaces to establish mechanisms, practical mechanisms that will enable us to move forward on this discussion on ODR and ADR. So the first session, as was mentioned by Prof. Subramanian and Dr. Fungula, will indeed focus on ADR, ODR, with a specific focus on the African Continental Free Trade Area Agreement, protocol on rules and procedures on the settlement of disputes. Thereafter, we will have our session 2, which will be chaired by my colleague, Dr. Rowena Bernard, who will be joining us online. And in that particular session, we will focus on ADR within the board's proceedings and a family mediation. And of course, session 3, we decided to have a general discussion, but we do have our presenters. Specifically, I'm going to mention them because of the impact that they've had and the presentations and the discussion that they've had at our ADR research interest group. And so after that particular presentations, we will then close by asking Professor Ernest Tenza to just give some closing remarks and also a vote of thanks by our other RIG members. We solely believe that the UKZN, which of course is the premier university of African scholarship, the School of Law, whose vision is to be a pioneering school of legal scholarship, is able to be one of the first to think of ADR, ODR within this particular context. But that this is not our first, this should not only stop here. We should continue and look at other means whereby we can continue this discussion, as this is part of our strategic plan on establishing ourselves as the as we are the premier university of African scholarship and as a leading school of law in South Africa as well as the African continent. Ladies and gentlemen, thank you so much for joining us for this opening session. We will now take a brief tea break and we will come back here at 10:20 to resume with our first session. Thank you.
Guys, okay, give us a chance.
So 90 people online was good.
Yes.
Didn't expect it.
Likely to be good. Yeah, yes. He's also getting the slightest feedback.
Depends on the speakers.
It's now.
No, no, I'm inside.
Will be back, the black one,
Yeah, I'll play.
the black one. The one that says we'll be back at 10.
Okay, let me go and make comments.
Okay.
Colleagues, hi, can you unmute the main point? Hi, Clyde. Yeah, we're getting feedback. Thank you.
Hello, good morning. Can you hear me, please? Thank you.
Good morning, colleagues. We are now back from our tea break. Thank you so much for those colleagues online. And of course, our colleagues who are attending the session in person. Thank you for joining us again for the session. Next. So the first session will be, as I mentioned previously, on ADR within the African Continental Free Trade Area. Excuse me, we're just trying to sort out some technicalities. As I mentioned to you previously, the session one is focused on ODR, ADR, within a specific context of the AFTA, the African Continental Free Trade Area Agreement, and of course the relevant protocol here is the protocol on rules and procedures on the settlement of disputes. Once again, welcome and thank you for joining us. Our first presenter is Dr. Victoria Olabedi. Dr. Olabedi Thank you so much for joining us. I just want to briefly introduce you to our colleagues. Dr. Victoria Olagbegi is a legal practitioner that's been called to the Nigerian bar. She's also a law lecturer, a researcher with outstanding doctoral and qualitative research methodology experience. She's described as a peace builder, very much innovative in terms of dispute resolution, as she's also a dispute resolution trainer and practitioner. She has a keen interest in and experience in international law, contracts, and of course, commercial law. She's equally well seasoned in advocacy, pro bono legal services and representation, criminal law, criminology, dealing with refugee issues, access to justice, diversity, and inclusion. Dr. Victoria's presentation is titled Bridging the Barriers, Fostering Alternative Dispute Resolution through Online Dispute Resolution Mechanisms in Africa. Dr. Victoria, thank you so much for joining us. If you can start sharing your presentation. Dr. Victoria, if you can unmute yourself and start your presentation.
Thank you very much. Good morning. There's 1 minute left. Can you see me, please?
It's okay.
Can you see me and am I audible? Good morning.
Yes, Doc.
Thank you very much. Please permit me to quickly share my slides.
Are you able to hear us, Dr. Victoria?
Yes, please. I'm trying to share my slides. Thank you very much.
Just give us a minute.
Can you see my slides, please?
Yes.
Yes, Doc. Please put it on presentation mode so that we can see them clearly.
Okay, thank you. Just 1 minute, please.
From beginning.
Is that fine, please? Okay,
Can you
thank
go
you.
to slideshow?
Okay.
Dr. Victoria, we're struggling to hear you.
From beginning.
Oh, yeah, from beginning. Thank you. Perfect. Thank you so much. Thank you very, very much. Thank you. Good morning. Once again, I wish to convey my very sincere.
You can start your presentation. Can you hear us on this side?
Thank you. Can I proceed?
Go ahead, please, Doc.
Thank you. So I wish to deeply convey my appreciation to Professor Subramanian and also the Dean of the College of Law, UKZN, and also the general, all the organizers of this very brilliant program. My name is Dr. Olagbegi Oloba Victoria Banke, and I'll be speaking on bridging barriers fostering alternative dispute resolution through online dispute resolution mechanisms in Africa. My presentation would examine the integration of ODR into ADR within the African regional context. I aim to assess challenges and opportunities, analyze the AFC FTA, African Continental Free Trade Agreement Protocol on Dispute Resolution, and also offer a few recommendations. As we all know, the African continent, the various countries within the African continent have diverse legal systems and cultures. And if we critically examine the history of these African countries and also their social backgrounds, their historical and social backgrounds, even the cultural backgrounds, we would realize that the fundamental way, the African indigenous ways of resolving disputes were very friendly. And within the South African context, it fosters the Ubuntu philosophy and reconciliation and also restorative justice. Now, within other contexts within the African continent, for those who do not understand this, the Ubuntu philosophy, for instance, let's take Nigeria, for example. In Nigeria, the predominant means of resolving disputes before the advent of litigation, which is perceived or which is borrowed. Let me use a simple English. According to the local people, and generally speaking, of course, it was borrowed, it was borrowed, received through the contact of the Nigerian people with the British people, colonialism. Yeah, so the historic and indigenous means of resolving disputes fosters unity, reconciliation, and it does not, encourage the adversarial means of resolving disputes. And if we now look at litigation is highly problematic, and that's the reason why we keep, we are now rethinking the road back to ADR. So litigation, as we all know, is often slow, cumbersome, complex, and inaccessible for all, against the background of the constitutional provisions in all the African countries, that founds and, encourages and even guarantees the freedom of the people to access courts. Beyond that, the people are not happy. The constitutional provisions are there, but the people are not enjoying the benefits of that provision. So what should we do? What should happen? Should we continue to wiggle and waggle and suffer in the problem, or should the system, especially we, the legal minds, start thinking out of the box and exploring alternative means of resolving these disputes? And this has taken us back to ADR, Alternative Disputes Resolution, which according to some scholars is the African, indigenous dispute resolution method. Now, ODR, which I would, unpack during the course of this presentation, and ADR has a couple of barriers. I will, speak more on this, but some of these barriers include limited digital infrastructure, low digital literacy, amongst others. Now, sorry. What is online dispute resolution? We all know that we all know what ADR is, I want to presume. But if we do not know, as mentioned during the keynote speech, the opening remarks this morning, ADR has to do with alternative means of resolving dispute. That is, other means through which you can resolve disputes other than through litigation. And such means includes mediation, arbitration, ombudsman, negotiation, and so on and so forth, early neutral evaluation, to mention but a few. But what we're looking at right now is how to leverage technology to engage and deliver effective ODR processes within the African continent, in South Africa, in Nigeria, in all other African countries, particularly to foster trade within the continent. So the use of technology, ODR simply put, is the use of technology to facilitate ADR processes. Examples are e-mediation, that is virtual mediation processes, virtual arbitration, virtual negotiation platforms, and so on and so forth. And the benefits are enormous. The benefits includes its cost effectiveness. A lot of scholars have argued that ADR is cost effective. So if we're saying that ADR is cost effective, in fact, employment of ODR, if effectively used, can even enhance that. In other words, using ODR, unlike dispute resolution, to facilitate ADR processes could be more, could be cheaper if effectively used. For instance, I've seen a country in Asia where once you have your phone, you can attend mediation, you can file your processes without legal services. And, just like you use the ATM machine to withdraw money, in that country, that's how easy they have tried to make dispute resolution, particularly mediation, online mediation, to be very effective. And when I saw that platform, I was like, this is more like, taking dispute resolution, opening access maximally, like in an unimaginable way. For instance, if we look at each of the African countries these days, there's hardly a community where you cannot find bank and the banking system. Okay, so let's just imagine a situation where people can also access dispute resolution that easily. So this is one of the things, one of the benefits that ODR, if effectively introduced and efficiently managed, this is just one of the benefits that the masses, particularly Africans, can benefit, from ODR and ADR. Now, it's important to ensure that there is effective synergy, like I was saying, between ADR and ODR, because, like I mentioned, ODR enhances ADR models, and it can, foster a more effective cross-border and multi-party resolution within the African continent. By and large, it has the potential to improve access for remote or underserved communities. Now, like I mentioned during the onset, during the commencement of the presentation, the implementation of ODR in Africa has a lot of challenges, which includes technological infrastructure gaps. For instance, within the local communities, where we have people who are not so educated and who cannot even afford mobile phones or even laptops, that might, be a challenge for them. Also, there's digital literacy disparity, mismatch with culturally embedded ADR practices. This is, I will unpack this later. This is of great concern, of more concern in my view, in addition to others. But there's the need to focus on this, and if this is very easy to unpack and very easy to address. So I'll just keep this and then discuss it later. And there's also concerns about trust, confidentiality, and accessibility. Again, I would say that all these challenges are very addressable. They are solutions to the problems, and it only has to do with the will. When the will is there, the way will definitely be there. But it's important that we are discussing all this now, towards considering how we can effectively address these challenges in order to maximally reap the benefits of the effective fusion of ODR into ADR models in Africa. Again, it's important to pay attention to cultural considerations that are being discussed currently. For instance, there's the argument that ODR, do not really foster Ubuntu, which emphasizes on community and relationship repair. Again, I would say that is debatable, and from my personal experience, I have not perceived it that way. So again, well, I don't. This is the introductory part, but I appear to keep, delving into the heart of the conversation. So for me, what you get in ODR, what you invest into ODR would likely inform what you would get from it. For example, if you use ODR very well, there's the possibility that the other party, the other person in the room might not feel the impact of your not being together physically. So it still depends on your skills and ability to close that gap. So ODR tools has been argued to often lack personal interaction. Again, that is debatable, but it's important for us to consider all this, And so there is, of course, based on this argument, the need to adapt platforms to local customs, design platforms that would meet the needs and align with the historical and social backgrounds of Africans. Okay, so that's a way of addressing these challenges that I've identified. Now, let's quickly look at the AFCFTA, that is the African Continental Free Trade Agreements and Protocol on Dispute Resolution. So I'll quickly look at, present an overview of the rules and procedures, the role of ADR within the protocol, and the need for modernization to reflect digital capabilities. One minute, please. Okay, so the AFCFTA governs intra-African trade under a structured dispute settlement mechanism. Okay, and the protocol is aimed at, so as we all know, there's the ongoing effort to ease intercontinental trade within the African continent, that is, ease of doing business on the continent. Now, we all know that once there's this interaction between two or more people, the possibility of conflict would become inevitable. Therefore, while thinking along the line of opening cross-border trade, seamless cross-border trade within the African continent, then it is important to also, along the line, think of effective dispute resolution mechanisms, that would be available as tools, dispute resolution tools for people to employ whenever they are in disputes. So the AFCFTA protocol has a dispute resolution tool mechanism, okay? And the role of ADR within the protocol is that it recognizes consultations, good offices, mediation, and also conciliation. And according to the protocol, ADR processes are voluntary and non-binding. And I need to say that for ADR experts, when we hear things like ADR processes are voluntary and non-binding, we need to understand that this is to the exception of arbitration. Arbitration processes are, highly regulated, and both the process and the outcome is, binding. However, for mediation, the process is non-binding, except where it is otherwise agreed by the parties. But generally speaking, the process is not binding, but the outcome is binding. Please, let's note that. So whenever we see things like ADR processes are generally voluntary and non-binding, please let's note that it's to the exception of arbitration. And also, most of the time, all other ADR processes, the processes are non-binding, okay, but the outcomes are generally binding. Once parties sign the settlement agreement, it becomes binding between the parties. And it is used to resolve disputes amicably. So it preserves the good relationship, business relationship between the parties. However, it is worthy of emphasis, it's worthy of note that ADR under the AFCFTA remains underutilized and it lacks institutional support. Now, there is the need for modernization. It's important also for the process, the protocol to embrace digital capabilities, because as the general saying goes, when you don't move with time, you get left behind. In this age and time, I am of the view that laws and protocols that are being promulgated or that are being any bill that is in the process of being passed into law, or any protocol, any legal instrument that we're working on in Africa should reflect the current realities. In other words, the protocol should embrace digital capabilities. And so first of all, let's look at the gaps. The protocol lacks integration of ODR tools. There's no framework for virtual hearings or e-filing. It also excludes private actors disputes, and we know that their roles are critical in trade. So it limits accessibility for smaller states and under-resourced participants. Now, let me just quickly discuss this in further details. Now, it has limited institutional support for ADR. For instance, there's no dedicated ADR body or mediation center under the AFCFTA. So for clarity, it might be important, for the African states to look into this. There's the absence of trained mediators or a roster of neutral facilitators. Now, it is also state-centric. It has a state-centric design. In other words, only state parties can institute disputes, okay, under the protocol. For instance, private sector actors who are major trade participants are excluded. Now, this creates a barrier for small businesses. This potentially creates barrier for small businesses and informal traders. Also, there's inaccessibility and there's the problem of inaccessibility and legal complexity. Under the protocol, it has been argued that procedures are complex and often inaccessible to smaller economics or poor resourced states. It has no simplified or expedited procedure for low value or small scale trade disputes. And this might be like more, it could be more, it might be more in number, and if we are really looking at expanding cross-border trades within the African continent, then it's important to also look towards this direction. It has been argued that the protocol lacks culture. It has cultural disconnect. That is, ADR under the AFCFTA does not reflect African indigenous values, such as Ubuntu, reconciliation, or community-driven solutions. It's been argued that it's missed opportunity to align ADR processes with traditional methods of dispute resolution. So looking at the AFC-FTA dispute resolution protocol, it's a very brilliant protocol, and I think it is a step towards the right direction. However, for us to get that maximum result that we're aiming at, it's important for the African continent to get things right from the onset. So looking at the AFC-FTA dispute resolution protocol, I am of the view and opinion that it has strong foundation, but there is the need for modernization. That is, it has to be designed to meet current needs and realities. It's important for it to be leveraged. I mean, it's important there is the need to leverage ADR and ODR to improve inclusivity, accessibility, and efficiency. Also, there is the need for it to be culturally grounded and tech-enabled. You know, such solutions can advance regional integration tremendously. Now, let's look at key insights and strategies that I'm suggesting. Okay, it's important for the protocol to be redesigned or upgraded to promote hybrid models that are tech-enhanced and community-based ADR. It's important to, you know, ensure that investment into digital infrastructure and training is prioritized. This is very important. I am an advocate of adopting, you know, innovations and adapting it to meet the needs and, you know, situations of the people. This is Africa. I see technological tools as tools that we can use, you know, to make life better for us. And I believe strongly that we can be intentional in terms of designing and developing culturally sensitive ODR platforms that would genuinely serve the needs of the African people. This would go a long way in fostering intra-African trade. And I am open to, you know, further discussions on this. It's also critical to encourage institutional collaboration across the African regions. Now, here are some I am suggesting a couple of roadmaps for implementation. Now, there is the need for policy reform and regulatory frameworks, you know, that would capture innovations and the current realities, like I've mentioned initially. There's need for capacity building, you know, on ADR and ODR for ADR and ODR professionals. And there's the need to devise technological innovations that would align with African values. This is very important. Let us, you know, when this is being designed, Africa should be the key focus, having the African people in mind and designing critical tools that will suit and benefit the African people. Okay, so it's also important to put in place to champion pilot programs in regional communities, because you know, while we're addressing the problem, we should address it from the top to the bottom, and more importantly, from the bottom to the top. Otherwise, there would be a disconnect and there would be that gap that, you know, we keep trying to address and bridge in Africa. No doubt, ODR presents a transformative path for ADR in Africa. And like I have mentioned, the innovation must be tailored to regional, cultural, and tech context. This is very critical. We must not miss out on this. It's important to, you know, deploy ODR, you know, infused ODR into ADR to foster inclusive, equitable dispute resolution within the continent. This is fully achievable. No doubt, Africa can lead in culturally grounded ODR and ADR systems. Again, I've, suggested some recommendations, most of which I have, explained already. Thank you very much for the opportunity. And thank you so much for, your very apt attention. Thank you so much. Thank you. So I'm open for questions and further discussions if possible. Thank you so much.
Thank you, Dr. Victoria. Very well said, very interesting points that you've raised throughout the presentations. And I just want to highlight those particular key issues. You can just stop your slide for Thank you, Dr. Victoria, as I've mentioned. The points that you have highlighted throughout your presentation resonates with the key points I raised at the introduction of our seminar. And I just want to go through those particular points. I mean, what better place to start off by reminding us about that this is about Africa, and of course bringing into the idea of humanity. And how we should resolve disputes, or the ideal ways in which we want to strive to deal with disputes, focusing on an African way of dealing with disputes, the importance of restorative justice, reminding us of colonialism and the impact that it has on the different African countries, different legal systems, and also the different levels of development. And that we are still struggling to develop our frameworks, institutional as well as legal, and that is in fact a particular barrier within the African continent. And of course, we come from different or diverse legal systems, and that needs to be recognized within the institution. So in other words, what we're saying here is that, and there's a particular point that Dr. Victoria raised, you can't develop policies, protocols, with a more Western view and forget that this is aimed at African countries or African people, finding a solution for African people. But we are missing the core points of developing these instruments. The PS has found that it's a mere copy and paste from the WTO or from other international organizations' instruments. But there is, in fact, and there is still an opportunity for us to develop the particular mechanisms to encourage institutional collaboration, encourage for further reform, and of course the regulatory framework. In essence, we also mentioned that this reminding us, because of the trade aspect, that we want to focus on fostering trade. We want to enable the countries to foster their trade, deal with those particular challenges. And of course, the challenge is in fact that we have underutilized systems, and that we do lack the institutional support. The key element of legal documents, policies, is the implementation of it. And the very last slides of yours, you're looking at ideas of how we can in fact implement this, not just be a pie in the sky, but think outside of the box, but look at how in fact can we make it relevant and practical to the African situation. And that there is indeed a need for us to look at modernization. If we are to access overseas markets, we need to modernize our current systems, and our systems involve dealing with disputes and how we're going to deal with these particular disputes. And very much you have encapsulated those particular ideas. I mean, you mentioned US pilot integration in our regional communities. I have a question for you on that particular issue. When we should be with the focus of international trade and these conciliation, mediation, and processes is in fact to persevere to preserve the relationship between countries. But is that in fact suitable for African countries and for African ways? I'm going to now look at see if we have any questions. Firstly, online, if there are any questions from our online users. There doesn't seem to be any questions from our online users. Before I just ask my question, Dr. Victoria, I'm going to turn to our in-person attendees. If there are any questions from our in-person attendees, any comments?
Thank you, Chair Dr. Stevens, and thank you, Banke, for that interesting presentation. One of the points that I noted in your presentation was you mentioned that a specific Asian country has used, if you have access to a cell phone, you're able to lodge documents and initiate the mediation process, which makes ADR more accessible. I thought that was quite interesting and innovative method. But given the challenges we face on the African continent in terms of technology and bandwidth and various other challenges, do you think that type of initiative will succeed in the African context? Thank you very much.
Thank you. Can the moderator, are you able to kindly summarize the question? I didn't hear clearly. Am I audible, please? Can you hear me? Okay, so online participants can hear me. Can the moderator hear me, please? Prof, if I am correct, will I be correct to say that, to assume that you asked whether ODR would be suitable considering that the infrastructural challenges that I identified in my presentation?
Dr. Banke, are you able to hear me now?
Yes, please, I can hear you now.
Sorry, my apologies. I think there's some technology issues. I think we're fine now. So the question related to your presentation, thank you for your presentation, first of all. Secondly, question related to, in your presentation itself, you mentioned that there's a specific Asian country that has allowed or has promoted access to ADR for citizens. And if the citizens or the applicants have access to a cell phone, they may be able to initiate the ADR process. And I was just wondering from an African perspective, and based on the research that you've done, based on our challenges on the African continent, do you think that type of initiative will succeed? Or do you think it poses more obstacles than benefits in that respect? Thank you, Dr.
Thank you. Thank you. Thank you very much, Prof. So when I saw the digital innovation, I realized that the company that designed the program, the owner of the company is someone that I know very well, and I contacted him to have a similar interaction with him. And while we were discussing, one thing that I realized is this. And I'm going to cite examples of South Africa and Nigeria. In the rural and very remote communities in Nigeria, we have banks there. And hardly will you see a trader, a local trader in Nigeria today, hardly will you see a local trader, even the elderly women, the elderly men who are trading in the markets in the remote communities, who would not accept transfer. That is, if you pay, now they allow you to pay, by transferring to their accounts, making bank transfers with your phone to their phones. And for me, that is an amazing growth and development. 4 or 5 years ago in Nigeria, we were not here. And we were not here. I mean, in this context, I am referring to the local traders in the remote areas. Yes, sometimes we have network challenges, you know, where network would affect the transfer, and sometimes that might affect trust. You know, they would say, I'm not sure if I'm going to accept that because I don't know if I would receive the alert or whether the transfer would go through. And then what I've seen people do is something like, okay, don't worry, I have all the patience. I can wait until you receive the alert. Now, using that knowledge and that observation, bringing it onto this conversation, the question of, you know, the person and I, we were rubbing minds, and the person was like, if that is possible, don't you think this is also possible using the same device but simplifying the complexity of the program? And for me, that is thought-provoking. I think with a pilot project, one can test run it. But with what I have seen, I think it is doable. Now, coming to the South African context, transacting with the local traders in South Africa, I think from my personal observation, quite a number of the local traders prefer ETF, like you transferring to them, than paying with cash, which means they have that basic knowledge of using the phone and using the banking system. So if you come from that angle, designing an ODR platform that will be user-friendly and that would not require much data. For instance, see the difference between Zoom and Microsoft Teams. If my data, my bandwidth is not that strong, I can do Zoom. But if my bandwidth is not that strong, I may not be able to join a virtual platform that is being enabled on Teams. So I think something is wrong somewhere regarding how these two technologies were designed. One was designed to use considerable level of data and, you know, easy to use for people, notwithstanding your level of education. In my personal view, it's easier for people to use Zoom than Teams. So since we are researchers, these are good topics for PhD students, for LLM students. You know, this is a brilliant topic for we researchers within the ODR and ADR field. This is what we should, I mean, these are things that we should collaborate on, look for funding and research on, you know, go into the field, conduct qualitative and quantitative researches to understand what the people want, how ODR would be designed, you know, to benefit the people according to the views and opinions of the people. That's what I think, Prof. Thank you very much.
Thank you, Jen, and thank you, Dr. Baki.
Thank you, Prof. Subramanian, for that question. Dr. Victoria, we do have a hand in for online users. Andisa Potwana, your hand is, you've raised your hand. You want to ask a question? You can unmute.
Good morning. Thank you very much for the presentation. I've actually typed my question by now, but perhaps I could expatiate on what I've already typed. I think the initiatives and suggestions and thoughts behind the presentation and what it suggests are actually great. But when it comes to the subject of diverse African legal systems and cultures, and by extension, norms and standards, and what is perceived to be Ubuntu, which I found that many people appear to have different perspectives on what Ubuntu is all about. The thought that I have in mind is if really there's an intention to use Ubuntu and restorative justice, given the background that I've given, that people have got different cultures, understanding of Ubuntu and so on, could there be a singular point of reference or a single point of reference where an entity or a country wanting to use ADR and infuse Ubuntu and restorative justice can then point out and say, okay, based on this cultural experience or on this definition of Ubuntu, this is how ADR should be approached. And before I step off the podium, perhaps I should add that gradually we are moving into we are already in a global village. We're seen as part of a bigger global village. So what the thought that comes to mind is, given that and international trade and so on, is there any particular value why we should be looking at African ways of resolving disputes rather than universal ways of resolving disputes, which of course would also include African ways of resolving disputes? Thank you.
Thank you very much. So I'll respond by answering the second question first before going on to the first question. So I'm an academic, I'm a teacher, in addition to being a researcher. And I would say that, first of all, we cannot build something on nothing and expect it to stand. That's number one. Then secondly, I'm a Nigerian from the Yoruba tribe, and there's an adage in Yoruba that says, Ile Latinko Eshorode. Now, the meaning in English, the literal meaning is that, okay, so charity begins from home, but now let me give it my own interpretation. It is from home that, like, your wealth, you take your wealth outside from your home, okay? And I am an African who believes strongly in Africa. And I hear you very well. I see your bigger picture, but I believe strongly that, first of all, we have to get it right from the inside, because globally, so many interesting efforts are going on there. And if we do not define what we want and how we want it to be done and how we would want to be treated on the global scale, then Africa will keep complaining of disconnect, would keep complaining of not being at the table when decisions are being made, when designs are being made and all. But I believe strongly that when we design ours from Africa, and we see that it's been used and implemented well for the people, and the people are happy, and it's fostering trade within the continent, and the continent is strong, I believe strongly that we'll have a very strong say at the international table. That's what I think. And that's why I think it is very, very important for us, to continue conversations on the African Continental Free Trade Agreement. For me, it's a beautiful agreement, and it's a step in the right direction. For instance, for those of us who travel a lot within the African continent, look at the visa regime within the African continent. Look at language barriers, look at infrastructural barriers, look at even when you the currency, the exchange program problem, when you want to exchange, those who are doing business within the African continent, they are going through a lot. They have their challenges, they have their problems. And I can assure you that the kind of problems that they experience on the African continent, they don't experience these challenges when they go to purchase or buy in China, or when they go to the US and other countries out there, outside the continent, because those people have made doing business internationally, they have eased doing business with the international community and the international world. And so I believe strongly that if we can get this right, It will strengthen trade in Africa and make Africa stronger out there and even more appealing to the international world. Now, I believe strongly that Africa is appealing to the international world today because we are like the gold, okay, that everyone wants to tap into. But I think we should appreciate our gold, make it useful for us within the continent, and then, you know, have that strong negotiating, strong bargaining tool, you know, against the international world. And so when we are at the table, we are there because we want to be there, not because we are there at anybody's mercy or because we need anybody's favor. Africa is blessed. Africa is rich. But what is the state of African trade today? And how is it affecting the local traders? And even how is it affecting the respective African economy and, you know, the overall African economy? So, I mean, my conversation is coming from this dimension, this perspective. And based on that, I believe strongly that we need to join hands together, join efforts together, you know, with the various regional organizations within the continent to strengthen this brilliant objective. Now, on to your first question. If I have the opportunity to implement such law or such standard or such protocol, what I am going to do, I will not target Ubuntu. I would look at the core principles in the Ubuntu philosophy, and then I would research similar principles, you know, from each African country, because when I want to present that protocol or policy to the people, my goal would be to be able to connect with the people, to be able to let the people know that I see them, I hear them, they are included, they are involved. Originally, I'm a Nigerian, but when I came across the Ubuntu philosophy and I started reading generally about it, there's just something that I keep seeing in all of the literature that I'm reading. I see love, I see community, I see unity, I see the need for people to be sensitive and, you know, see things from the lenses of the other person and realize that my liberty, if I misuse it, would affect yours. If you misuse it, would affect mine. In order for us to continue to live together as one, as a community, it's important for us to keep respecting each other and also to love each other. That's the way I see it, using my own layman's English, a non-South African English. So that's what I think. I think that as researchers, we should look at this philosophy, but if I want to present it to a Zimbabwean or a Nigerian or a Ghanaian, I won't say this is from South Africa, because the person would push back and say, why are you trying to impose a philosophy or a doctrine from South Africa on me? Rather, I would look across board for similarities, and then I would design something for Africa. So I only cited that as an example. And while citing it, I also mentioned that we have something similar in every African country. And looking at the history, I mean, litigation was not something that has been there from inception. What was there was, you know, family unity, communal unity, you know, resolving disputes, calling the elders within the family to intervene, calling religious leaders, and so on. And so it's important for us to keep holding onto these strong values and keep promoting them for a better Africa, and also using it to foster trade within the African continent. Thank you.
Yeah, thank you so much, Dr. Victoria. Here in the in-person, with the in-person attendance, there were several agreements with many of the points that you've raised. We are not against universal, the inclusion of universal concepts etc. But we want to emphasize the African voice. And many of those informal traders are, of course, women, who are a disadvantaged group in our society and who struggle with finances, etc., to enable them to participate and to use trade as a means to reduce poverty and so forth, and also address their socioeconomic challenges. Dr. Victoria, we also have a comment in the chat from Nolundi Shezi. Nolundi says, I think another challenge is what will be the criteria to recognize the accredited ODR, ADR practitioners for the cross-border disputes? Do you maybe just want to give us your brief view on that?
Thank you very much. So what I think is that
Dr. Victoria, just hold on, please. Can you just hold on? Yes, there's a question. The second question was the subsidiary question to that particular comment.
Yes, it is. So I'm glad that you read out the comment by Nolumbi Shezi, because that was what I was going to do, and then piggyback on that question or comment. I'm glad, Doc, that you raised the fact that within the African continent, we have both developed and least developed countries. And you recognize that accessibility is a challenge because of these variances. So on this, you also have emphasized the importance of community resolution of disputes. Now, piggybacking off Nolundi Shezi's comment on what I would say is our obsession with accreditation, and as legally trained people or anyone, as people approach dispute resolution from the mainstream professional perspective, how do you see our thinking of things need to be accredited? A person needs to be trained in such a way and actually certified before we can allow them to intervene in and practice ADR in situations with this very necessary situation that you've highlighted of ensuring that we're starting from home, we're starting from the wealth that we have, and community dispute resolution. Thank you. That's my question.
Thank you very much. Thank you very much for the brilliant questions, very important questions. So my component, my presentation focuses on trade. I've seen the program and I know that there are some presentations that would come on, family law and some other aspects of the legal profession or practice, mediation practice or ADR practice. In terms of trade issues are different and should be treated as such. Each dispute resolution issue should be taken with great importance and treated with the importance that each deserves. In business, what an average businessman would likely focus on, looking at things from the perspective of the two parties. One party might be looking at the business relationship between them. The other party might be looking at money. Okay, and both of them might also be looking at money because we're talking about business. I hear you, I understand you, but then if we want to consider the interest of these people, then we must ensure that people who would resolve their disputes would be people who understands their languages, the business language. For instance, I would not bring a traditional leader to resolve dispute for. I'm between two businessmen, especially someone who has no background and experience in that wise. And that is where regulation comes in. Well, I am different from other scholars. My own perspective has always been, it's okay to see what is going on out there, but it's more important to adapt to the needs of the users, something that would connect with the users if I want it to work. If we're talking about family mediation, it's also different. And so each of these issues should be treated with care and caution so that we won't be creating problems while trying to provide solutions. Therefore, in terms of ensuring that there's a roster, there's accreditation, these are areas where we should focus on. Who should resolve this kind of disputes? What kind of background or training should the person have? How should we design that? And then we should design it from within Africa for Africans. And then we should train. And if there are people who already have the training, no problem. But there should be a program, that would bring them in tune with the protocol of the African Continental Free Trade Agreement. There's a general saying in my language that where there is no regulation, there is no sin, there is no offense. So it's not about, I know what we have in mind regarding accreditation, or I think I can imagine what we have in mind whenever we hear accreditation and practitioners and, rosters and all. But I think we should be intentional now that we are starting from the scratch, so to speak, by avoiding problems and focusing more on solutions based on what we have heard and seen in the past, and also involving and including the people. That is, we should be intentional from the onset. Now, regarding the issue in the chat that deals with recognized accredited ODR and ADR practitioners across the border. Now, one thing that I know is that, for instance, the AU, they have a roster of ADR practitioners. We know this. The United Nations, they have theirs. Most of these international organizations and regional organizations, they do have all these rosters. And people like you and I are practicing there. And what I have seen is that what they do is not different from what we do locally. The only difference might be that fitting into the situation, the current situation, which means we might need to up our skills and probably take their specialized trainings. Now, speaking from experience as an ADR practitioner, I believe strongly that if the process of coming up with the regulation and accreditation procedure is open and transparent, for instance, looking at the key ADR bodies in each country and involving people from these ADR bodies, hearing their views and suggestions and recommendations in terms of designing the protocol or the regulation, I don't think there will be any problem. If there's transparency and inclusivity, most of the time people would not kick back. And as professionals, if I can, move from one country to the other, and I'm being practical now, professionally, we move across countries, across region, we look at what is possible there, we practice, we adapt, and we are thriving well, then this can also work. Like I said from the onset, when the will is there will always be a way. It's all about us. I know, I have seen that when we are determined to solve problems, we solve. But the question is, are we ready now? Thank you very much.
Thank you, Dr. Victoria. I'm not going to ask or pose my question because, in fact, you did answer it in your responses to our colleagues. But just one particular point from what you have mentioned is that we need to be clear, have a clear and cautious approach when dealing with ADR, ODR, or with these particular mechanisms, processes, and so forth. And if I have to just briefly summarize, Dr. Victoria, the points that you've raised, ultimately, if I can say, in order for us to ensure or to realize ODR, ADR within the African system, we need to be mindful of the African legal socioeconomic context in resolving disputes. And of course, this is a critical and ongoing debate, and it requires further analysis. And in order for us to enable that analysis, we need to be mindful of the current challenges that African regional economic communities face, as well as individuals, because we need to be mindful that there are, in fact, barriers. And those barriers are affecting our ability to trade, to access markets, and that we need to focus on fostering regional cooperation and integration if we are to meet the Agenda 2063 goals and have the Africa that we want. Dr. Victoria, thank you for your presentation, your insightful views, and of course, answering the questions and giving your insight on the comments from the panel, from our in-person as well as our online panel. Thank you so much once again. Of course, we will continue with this discussion. This is not the end. We will continue with this discussion. And thank you, Dr. Victoria. Ladies and gentlemen, unfortunately, our other presenter is not here. So we will take a 5-minute break to give the second session opportunity to just sort out their particular technicalities and so forth. We will resume at 11:35. Thank you once again, Dr. Victoria.
Thank you. Thank you very much. Thank you. The College of Law is doing, you're doing well. You're doing brilliantly well. And I am very honored to have been invited to speak on this very important topic. Thank you very much for all you do. The RIG, thank you so much. And thank you, Professor Subramanian. Once again, I appreciate you. Thank you, everyone. Thank you, the audience. Thank you. I appreciate you. Big thanks to the professors and doctors in the room. Thank you.
Okay, thank you, ladies and gentlemen. And we're now going to start with our second session. The chair for this session will be my colleague, Dr. Rowena Bernard. Dr. Rowena will share this particular session. Dr. Bernard, I'm handing over to you.
Good morning, Dr. Stevens.
Just hold on,
colleague-
Dr. Bernard. We're having a problem with the volume.
Okay.
Dr. Bernard, can you hear us?
Yes, I can.
We can't hear you. There's a problem with your sound on your side.
No, there's no problem.
Me? Dr. Stevens, can you hear me?
We can't hear you yet. The in-person audience is struggling to hear you. Just give us a minute.
Okay. I've got my microphone as loud as I can. Can you hear me?
No, no. Sorry, where now?
Dr. Bernard, can you speak now?
Can you hear me?
Yes, we can. Thank you so much for that.
Clear and loud and no issues. Good. Can I proceed?
Yes, you can.
Thank you. Good morning, Dr. Stevens and colleagues, both online and in person. I am the chair for this particular session. The session that we are going to be running this morning is entitled Online Dispute Resolution or Alternate Dispute Resolution within Divorce Proceedings and Family mediation. Very briefly, in terms of this particular area that we are focusing on, just by way of introduction, alternate dispute resolution methods, particularly in mediation, offers a less adversarial and more collaborative approach to resolving disputes within divorce proceedings and family matters compared to the traditional litigation route that we know of. Family mediation specifically provides a more structured approach for couples to reach mutually agreeable settlements on issues such as child custody, the division of assets, financial support, as such. So it's formalities and processes that occur outside of the formal court system. So this morning we have, for this session, three experts in the field that will be indicating and highlighting and presenting to us on very relevant and pertinent issues regarding ADR in family issues. So the first presenter that we have for us this morning is Dr. Juanita Estop, who is also a colleague of mine. And Dr. Estop is a lecturer in the field of family law, gender and the law, interpretation of laws, and the law of contract. She holds several degrees, which include an LLB, an LLM, and a PhD degree from the University of KwaZulu-Natal. She is also an admitted advocate of the High Court of South Africa, and she is an accredited mediator. Her main research interests are in the areas of family law, international humanitarian law, human rights law, labor law, and religion and the law. And she has presented numerous papers on various topics on family law at family law conferences and at the South African law teachers conferences. Colleagues, it is my honor and privilege to hand you over now to Dr. Easthop. I am going to mute myself, and for purposes of giving full dedication, I will also switch off my video and come back at the end of her presentation to you. Thank you.
Good morning, ladies and gentlemen. My topic today that I'm going to be talking very briefly to you about is the examination of the legal and ethical dimensions of AI in family law mediation. This topic really came on because of the South African mandatory mediation directive that was issued by the Judge President of the Gauteng High Court. So mediators immediately kind of scurried around. They're under a lot of pressure. Their client base is going to build quite extensively. So there needs to be a way where family mediation can become just a little bit easier because of all the pressure. But we all know that family law mediators spend much of their time and energy working with their clients who are often going through some of the toughest and most challenging emotional experiences of their lives, which makes these cases slightly more complex and unique. When family mediators are dealing with real people and real emotions, it's really important for clients or the parties and the mediator to build a relationship of trust. And this trust relationship is one of the most important components of family mediation. According to a Stanford's AI Index report of 2024, AI now outperforms humans in several areas, from reading comprehension to helping us by automating image classification. So really, this progress is helping us to automate routine tasks like document analysis, scheduling mediation sessions, eliminating that geographical barrier and boundary, and making dispute resolution more accessible through online platforms. So for mediators, this means a greater efficiency and reach, but it's important to remember that AI should be used as a tool and not as a substitute for mediators. Simply because it can't replicate that human skill that is essential to mediation, skills such as empathy, ethical judgment, or understanding emotional nuances. So mediation, like I said to you, is one of the main methods in family dispute resolution. And its aim is really sorry about that. That was a technical problem, ladies and gentlemen. So mediation is one of the main methods in family dispute resolution. And its aim is really to reach an agreement amicably between the parties without them going through these lengthy and exhausting court proceedings and litigation, which is really just going to traumatize these parties even more than they are. So AI does have the potential to assist in various stages of family mediation. For instance, it could be used in assisting with summarizing the main issues brought up in the initial consultation, in order that the mediator can understand the issues clearly. It can assist in financial calculations for maintenance, pension payouts, property division. It can even draw up parenting plans. And of course, it can also look at childcare and contact and much more. But one thing that must be remembered is that the human element is still available there and must be available because of the data that it must put into AI for AI to recommend outcomes that are plausible. It can also be helpful in assisting a faster intake of clients. It can be available to clients 24/7 for basic support. It can translate language and standardize communication, which will improve access, particularly in underserved communities. But while AI is able to do all these things, there are some challenges in the application of AI in family mediation. Where AI can excel at performing routine tasks, situations that require creative intelligence are often outside the scope of AI as it exists currently. So consequently, AI cannot grasp overarching principles of justice and unwritten rules of dispute resolution. So human arbitrators, on the other hand, are not limited in the application or interpretation of relevant law and the issues that arise in family mediation. So even though humans can't compute these large amounts of data at the speed that AI does, we can analyze the facts of each case and tailor legal principles to either uphold or develop a new legal doctrine. So according to researchers, despite all its computational ability, AI lacks basic common sense that allows humans to not only resolve disputes, but to do it in a meaningful fashion. Human intelligence is something that is of absolute importance here when it looks at the challenges. Sudin and Coombs argue that regardless of how sophisticated a decision-making algorithm is, emotional intelligence still cannot be encoded into it. So human decision makers have an emotional grasp of the issues parties are facing and are able to ask insightful questions and can delve into complex matters to facilitate a resolution between the parties. Waits and Lawrence, in their article, The Art of Advocacy in International Arbitration, believe that human arbitrators make their decisions based on their life experiences and their understanding of their world around them, giving them the ability to relate with the parties involved in the dispute. AI, of course, is capable of interacting with people, but it does this without the empathy, the compassion, or intuitiveness, which means that parties may lose confidence in the mediation process. So empathy and communication skills are essential for mediators to possess, and because this is what parties are looking for when looking for a mediator suitable to deal with their specific issue. So the complexity and emotional nature of family mediation is unlike any other dispute resolution or alternative dispute resolution, which tends to be more fact-based. Family law mediation often involves psychological, social, and cultural aspects that are difficult for algorithm-based systems to understand. So understanding the emotional and social dynamics in family mediation is critical for human mediators, simply because human mediators need to demonstrate emotional intelligence, empathy, and a deep understanding of both the law and the issues involved in that specific mediation, qualities that AI lacks. Furthermore, AI fails to understand the moral and ethical aspects of complex social and cultural contexts involved in family mediation. So to this extent, the validity and accuracy of the recommendations generated by AI may be questionable, as it may be biased and discriminatory. But there are global trends all over the world, and I'm just going to mention 4 of them, and I'm sure there's many others, but this is solely in relation to divorce and family mediation. In the US, a study showed that the use of AI in divorce mediation can reduce case resolution by 40%. In the UK, an AI-based system developed by government has helped in managing child custody cases more efficiently, with the user satisfaction rate of 85%. In Canada, the AI-based system assists in resolving high-volume, low-intensity legal disputes. And in Australia, its AI-based platform was designed to aid couples separating or divorcing. But in saying all this, there are definitely legal and ethical considerations. So the integration of artificial intelligence into family law mediation in South Africa presents both legal and ethical challenges that must be carefully navigated. Family law cases often involve, like I said to you earlier, sensitive personal information, such as financial records or communication logs. Family mediators must ensure that the use of AI does not compromise the privacy and the confidentiality of their clients' information. And to prevent any of these risks, mediators should only use secure AI tools which guarantee data privacy. As POPIA imposes strict obligations on data processing, mediators must ensure that reasonable steps are taken to safeguard client information and to ensure the confidentiality and privacy of highly sensitive personal data. So informed consent is also essential, as parties must fully understand the role and limitations of AI in the mediation process. And because family law cases are complex and unique, it is challenging for AI to find relevant and reliable data, which may lead to potential biases in the predictions that it's going to generate. So questions of legal accountability will then arise, where AI recommendations lead to unfair or harmful outcomes, which raises concerns about liability. So although AI may reduce costs and improve efficiency, unequal access to technology may exclude vulnerable groups from attaining the justice which will potentially reinforce inequality, which is a basic human right in terms of Section 9 of the Constitution. And another important factor that cannot be forgotten is the best interest of the child, which is of paramount importance. And this is stated in Section 28(2) of the Constitution and Section 7 and Section 9 of the Children's Act, as well as Article 3 of the Convention on the Rights of the Child. This means that any AI tool used in mediation that involves children must be evaluated to ensure it's using supportive information rather than undermining the constitutional principles and the best interests of the child. There are also ethical implications and considerations that must be taken note of, simply because the use of AI in mediation is limited by its lack of empathy and human judgment. Qualities, like I said, are essential in resolving complex family disputes. So while AI may enhance access to justice through greater efficiency and lower cost, it risks reinforcing those existing inequalities if vulnerable parties lack access to digital literacy or to technology for that matter. Moreover, transparency and explainability are crucial. So opaque AI systems may undermine parties' trust and the voluntary nature of mediation. Furthermore, AI systems may reflect or amplify biases in the data they were trained on, for example, gender, racial, or cultural biases. So in family mediation, where outcomes can deeply affect people's lives, these biases may result in unjust or discriminatory recommendations. And as mediation is a voluntary process, if AI influences any of the decisions too strongly, it may compromise party autonomy. So it may, human mediators must then retain control and oversight to ensure that AI recommendations do not ride that human judgment. So trust between mediator and the parties concerned is foundational in family mediation. So the over-reliance of AI may erode this type of trust, especially if the parties feel that they are being judged or managed by a machine rather than a person. But there are developments that are taking place in South Africa, because one of the things that you worry about is there going to be a legal framework in place for issues such as this? So we have a Rule 41A of the Uniform Rules of Court and Chapter 2 Mediation Rules of the Magistrates' Courts that require parties to indicate their agreement or opposition to mediation in new legal proceedings. So failure to engage in mediation without valid reasons may result in punitive cost orders. During 2025, and like I said in the beginning of this presentation, the Judge President of the Gauteng Division of the High Court issued a directive requiring parties in civil matters to participate in mandatory mediation before they may apply for a trial date. And this is in an effort to reduce the overcrowded court rolls. So the Judge President has further indicated his intention to extend this requirement to all divisions of the High Courts in South Africa. So the South African Law Reform Commission, in its discussion paper 148 of 2019, proposed a draft family disputes resolution bill, which aims to make mediation mandatory in all family law disputes before the parties may approach the court. The final report on this project has been approved by the SALRC in December 2024. The SALRC has also released discussion paper 94 of 2025, which provides for a draft generic mediation bill aimed at creating a uniform legislative framework for mediation across all areas of civil law. This proposed legislation marks a significant step toward mainstreaming mediation and ensuring consistency in its application. So these developments collectively signal a clear trajectory toward mediation becoming an integral part of our formal justice system. But having said all of that, ladies and gentlemen, what has this got to do with AI? Because of the mandatory mediation directive, like I said at the beginning, mediators are scrambling. Clients are increasing exponentially. And so we need to find an easier way to do this. But as family mediation is deeply human and complex and fraught with many emotions that both mediators and parties alike need to navigate, human judgment is absolutely essential. AI cannot replicate human skills essential to mediate, like empathy, ethical judgment, or understanding emotional nuances. So AI should be used as an assistant tool and not as a substitute for decisions made by human mediators. It should not replace human mediators, but it should rather empower them to work effectively. With many lived realities involved in family mediation, mediators need to shape AI and not the other way around, which may be harmful to the parties concerned. So in South Africa, the use of AI in family law mediation does hold promise, particularly in improving access and efficiency, but it must be carefully regulated and ethically grounded. So at the pace at which AI is moving, it needs to be used responsibly. And one way in which to do this is to create training programs for all family and divorce mediators. So, ladies and gentlemen, finally, in legal safeguards and ethical considerations must guide AI's implementation to ensure it supports rather than undermines justice in family matters. Family mediation must remain a space of dignity, empathy, and fairness. Thank you very much.
Thank you, Dr. Esther, for that insightful and outstanding presentation. I'm sure that our colleagues will agree that it was very informative, especially with the impact that AI is making in our society today. Just to highlight some very important points and to summarize what you've indicated in your presentation, you very articulately set out the advantages and the benefits as well as the challenges to the usage of AI in mediation when it comes to family issues. And at the same time, I think the challenges that you noted were very critical to our engagement in the mediation process. And importantly, you've highlighted the ethical and the responsible usage of AI during mediation. Also, at the same time, you've outlined our legal framework, highlighting the directive that was issued by the Judge President of the High Court, motivating for the need for us to use and engage in mediation. And I'm glad that we are looking at more innovative and creative ways to encourage mediation in our society, because litigation is not always the best way forward. And so as we proceed, as you've highlighted very nicely, is that there is room for AI in our society, for the usage of AI in family law mediations, but that we need to be very responsible in how we use it to ensure that children are safeguarded, that they are protected, and that their well-being is first and foremost on any agenda when it comes to this mediation. So on that note, I'm going to say thank you to you for that insightful presentation. And then we won't take questions at this point. At the end of the session, we will then open the floor to questions for you. Unless, Dr. Stevens, you prefer for us to take the questions now? Or should we just proceed as per the program?
Yes, I think Dr. Stevens says the next presenter could
Perfect.
start the presentation.
Thank you so much, Dr. Eastock. Okay, thank you very much. So we move on to the next presentation that is on our program. And Esther, please forgive me for the pronunciation of your name, right? But I'm going to try my very best to pronounce it correctly. So with us, we have Mrs. Esther Aldertime, who is going to be presenting to us on the re-emerging family justice in Africa, integrating ODR and ADR within customary court systems for divorce and family-related disputes. Esther is an experienced legal practitioner with a demonstrated history of working in the legal services industry. She is skilled in legal research, legal writing, litigation, legal advice, and civil litigation. She is a strong legal professional with a Bachelor of Laws degree, and she is an associate member of the Institute of Chartered Mediators and Conciliators. Colleagues, please allow me to introduce to you Mrs. Esther Aldertime. Thank you. I will mute and put my video off. Thank you.
Good morning, everyone. Sorry, can you hear me? I'm having issue with my network here. Good
Esther,
morning,
I can hear
everyone.
you. I'm clear. I'm not sure. Dr. Stevens, would you be able to confirm?
Yes, we can
I'm
hear.
having,
Esther.
yeah, I'm
Okay.
having issue with my network right now. So I need to share my screen as well.
Yes, please.
Oh, can you see me? Right now, my system, my network is jammed presently.
From our side
Wow.
online, your video is very
It's
distorted.
blurry. Yes. I'm trying to see if I can. Please, can you give me about 5 minutes? Maybe I can switch to PC.
Dr. Stevens, is there any way for you to project from your side?
Unfortunately, we don't have Mrs. Esther's presentation, Dr. Bernard.
Okay.
Okay, probably if I can send the presentation, would that be okay?
Yes, yes, you can do so.
Okay, let me quickly send it right now.
Thank you.
Ask her to remove her background. Yeah. That's a toilet. Yeah. Okay.
Esther, while we wait, could you please also remove your background image so that we can see it clearly?
Okay. Can you see me now?
Okay, please switch on your video.
Okay.
That's much better. Oh, no, no. Esther, please just remove it.
Sorry? Pardon?
Remove the background, please, Esther.
Okay, I think I've done that. Okay,
That's better. Thank you.
thank you very much. I'm looking, I want to share my slide, if possible. I'm trying to, okay. Miss, can you give me about 5 minutes in order to switch to PC?
Dr. Stevens, while Mrs. Esther is busy trying to sort herself out and emailing you the slides, in the interest of time, may I suggest if our next presenter, Ms. Nomfundo Mthembu, is ready, that we proceed with her presentation?
Ms. Nomfundo is online. Ms. Nomfundo?
Yes, she's just joined us.
Ms. Mthembu, sorry, we can't hear you.
Yes, hello, I can hear you, Dr. Bernard.
Great. Are you able to present at this stage, or do you also require a few minutes to set yourself up?
I was scheduled for 12:20, but if I'm required to, I'm happy to go ahead.
No pressure. We can wait for you, but we haven't had Mrs. Esther's presentation as yet. She's got a bit of technical challenges.
Okay, I understand. I think we can go ahead with my presentation so that Miss Esther can get time to compose herself and be able to project her presentation. Just give me 1 minute so that I can also try to connect and project mine.
No problem. You let us know when you are ready. Thank you.
Okay, colleagues, in the interest of time, can we go back to Esther? Esther, can you try and share your screen now?
Esther, sorry, can you hear us? We can't hear you. I think you need to unmute.
Esther?
I think we've got some serious technical issues going on here with Esther Hazel. We'll just wait for Nomfundo to see what's going on.
Okay, no, Nomfundo is ready. Claudinia.
Hey, Ms.
Thank
Nomfundo, you
you.
can start sharing your screen. I'll hand over to Dr. Bernard.
Thank you very much, Dr. Stevens. Thank you, Dr. And Ms. Langa for that. Colleagues, sorry about the technical challenges, but we are now ready to proceed. So our next presentation that we have on the program is going to be delivered by Ms. Nomfundo Mthembu, who is also a colleague of mine. And she is going to be presenting on navigating conception and conflict, exploring mediation in South Africa's assisted reproductive technologies spaces. Ms. Mthembu holds a Bachelor of Laws degree as well as a Master's of Law degree in medical law from the University of KwaZulu-Natal, and she is currently pursuing her PhD in medical law at the University of KZN. She is a co-investigator in a research project that is funded by the Competitions Commission South Africa, and she has served on the Research and Higher Degrees Committee of the School of Law. In terms of her commitment to community engagement, she has served as a member of the campus HIV/AIDS support unit in their peer education program. Colleagues, it is my pleasure to hand over to Ms. Mthembu, who will take us through her presentation. Welcome, Ms. Mthembu.
Thank you, Doc. Good morning, colleagues, esteemed panelists and organizers of the seminar. I'm very excited to be here. I've been listening, and this is quite a lovely interaction. And in fact, some of the panelists have already presented on what I wanted to present, but let me give it a shot. But I did hear some of my own thoughts in the room. So my topic is navigating conception and conflict, exploring mediation in South Africa's assisted reproductive technology space. Now, I think from the topic itself, if I can just unpack, here I want us to look at conflict and conception, which these two words themselves, it's quite ironic, you know, what conflicts can arise out of conception. But we've seen that with the advent and the rise of assisted reproductive technologies, which are these new ways of conception, there has been a lot of conflict, and this conflict impacts on individuals and the global debate around reproduction. So what is assisted reproductive technologies? I'm trying to make my screen to be full screen. How do I do that, colleagues? I'm sorry.
Please go to slideshow.
Yeah.
It's a toolbar right at the top of your screen, and the red toolbar. You'll see an icon called slideshow.
Okay, I can't see it, but it's
on top bar slideshow.
Slideshow, yeah.
Yeah.
Top bar slideshow.
Oh,
it's in white writing.
Left. There.
Okay, thank you. Thank you so much.
Thanks.
So, what is ARTs and what are these conflicts about? So assisted reproductive technologies are medical procedures that are used to help individuals and couples with infertility to achieve a pregnancy. These techniques include IVF, ICSI, and other interventions that assist couples and individuals to overcome infertility. So if this is the new technology that we have now in order to start families, what could possibly be the problem? So what we have seen is that these technologies now that you can almost make a baby in a laboratory, in the words of some authors, has posed a challenge to traditional beliefs about family procreation, the sanctity of life, and has created some form of friction between religious doctrines, cultural norms, personal convictions in terms of how we see family structures. Furthermore, the individual choices regarding ARTs are deeply personal, and they often involve emotional, psychological, and financial consideration that lead to complex internal and external conflicts and societal debates. Let me give you an example. You have a couple who are infertile, and they donate their gametes. The lady donates an egg. The husband donates his sperm, and once it's fertilized, they have an embryo. But by a stroke of unfortunate event, they break up. What the first conflict there is that who now owns these embryos? Should one of the parties, for example, want to continue to with that particular pregnancy, but the other one does not because of the breakup? These are some of the conflicts that we see in the pursuit of these of families using ARTs. And these problems often end up in court and through litigation. And the question is, which I want us to discuss here, is that is litigation an acceptable or the best method of settling such disputes? So, having given the introduction, the background, I just want us to explore the growing demand of ARTs in South Africa, which we have explored. And one of the problems is the rise in the legal and ethical complexities. Now, the rise in legal complexities or legal challenges, if I can just put it like that, in medical law didn't come with reproductive medicine now that people are using IVF and all these technologies to start families. Medical law in South Africa, you would know that the Department of Health spent most of its budgets, or a huge chunk of it, therefore, in litigation, in settling disputes arising out of medical malpractice, medical negligence, or in that context. So what ARTs has done is throw in a new spanner in that work and just literally added more litigation, more complexities into an already complex system. And why we must explore mediation as a non-adversarial conflict resolution tool. And here, colleagues, I want us to explore this. And one of my colleagues here in the session mentioned this. Mediation is not new. In fact, authors who are arguing for Africanization of medical law will say that mediation is the conflict resolution tool from an African perspective. So sometimes when some authors will say we are introducing mediation, we can't be introducing a system that indigenous people have been using for years. So some of the debates around that, and which we need to settle, even mediation in family law, it didn't only come as new with the rules of the court. It's something that has existed for years, for centuries. Mediation has always been a conflict resolution in family law. But how can we apply it now in these technologies, in this context, that the challenges that these new technologies present? So if you look at the South African context, we've got diverse population with different reproductive beliefs. Now, what does a cultural diverse population with different reproductive beliefs mean for this new technology and the regulation thereof, or the settling of disputes that arise?
Colleagues, sorry, are we still online?
Yes, we are, Dr. Bernard. I think we have a problem with Ms. Nomfundu's presentation. Maybe she has some technical difficulties.
Okay, shall we give her a second or two to try and reconnect?
Yes, please.
Thank you.
While we wait for Nomfundo, Esther, are you back?
Yes, I want to apologize for the little delay I have usually with technical issues.
Okay.
I'm so sorry.
All right. So we'll just give Nomfundo a half a minute or so, and then we'll come back to you.
Thank
Are you
you.
able to share your screen now so that we can get that out of the way as well? While we wait.
Good afternoon.
Hazel, sorry, will you be able to let me know if Nomfundo has rejoined? Because I cannot see the list of participants, so I can't see her.
Yes, we'll advise.
Thank you.
We'll let you know. Are you winning, Esther?
Hazel, I see.
Nomfundo is back.
I think, can we proceed with Nomfundo then, since she was in the middle of the
Yes.
presentation? Nomfundo, welcome back.
Thank you, Doc. Apologies, colleagues. Those are the benefits of online, but I'm back now and I will resume where I was. Okay, thank you. I was explaining about the issue of the diverse population with different reproductive beliefs and an evolving legal framework around fertility treatment, and why we need context-sensitive solutions and we do not need a blanket approach that litigation offers. Litigation is not a way to end the conflict. I mean, litigation is not a way to resolve the conflict. Apologies for that. It is a way to put a stop to the conflict. It is a way to end the conflict. And issues around family law, issues around conception, parenthood, building families, those issues need a more holistic approach of conflict resolution, which mediation already allows for. And if you look at, for example, the cases that we've had in medical law, in assisted reproductive technologies, in terms of the interpretation of surrogacy laws, they do not give context-specific solutions. The judges or the courts, the jurisprudence that is coming out of the court does not seem to work on a case-by-case basis, but it seems to work on a regulatory basis that moving forward, this is how we should resolve this type of disputes, which if you look at family law, if you look at medical law, we should be using the opposite approach, which is why I'm advocating that we have this mediation system in the African context that can be a viable tool on how we resolve these types of conflicts. Now, what is mediation, and most importantly, why is it important in this context? Again, mediation seems to, unlike litigation, when you litigate, you are compelling basically the other party to be a part of the litigation. There's no other way. But when in mediation, we encourage that the person voluntarily, confidentially, subject himself or herself to the mediation process, and he or she fully participates, is a part of the solution. Whereas if you litigate, in a way, you are not part of the solution, but the solution will be given to you, will be handed to you in the form of a verdict. Whereas in mediation, for example, in parenthood, in family matters of conception, we encourage collaboration versus litigation. We encourage a negotiation process of reaching the outcome. And here we look on shared interest and mutual interest of all the parties, which you will not find in litigation. In litigation, it's either or. Litigation is not there to ensure that the defendant and the plaintiff walk out of the courtroom both happy, which is very, very dangerous when litigation is used in family law. My colleagues have already alluded to this, especially in matters that affect children, that affect families. Now, how do we apply mediation in reproductive medicine, in assisted reproductive technologies? So as I alluded to earlier on, there are always disputes in conception, especially disputes now that we are using assisted reproductive technologies to form our families. You know, reproduction is no longer what it was 100 years ago, where it was just a gamble and there was no complications, hardly ever any conflict. But now with these new technologies, there is disagreements on treatment plans, on the outcome. There's disagreements on whether the couple wants a baby boy or a baby girl, because with IVF, with these medical technologies, the spectrum of choice has been expanded to actually now invite conflict. So that is how we apply it, and that is why we should in fact encourage it and apply it moving forward. The legal framework, I've already alluded to this. We've got the Children's Act, we've got the National Health Act, we've got the regulations regulating artificial fertilization. Again, the law provide a blanket approach, a blanket regulatory approach. Whereas if you look at the issues that need to be, the disputes or the conflicts that need to be settled when we look at when parties are undergoing assisted reproductive technologies, you can clearly see that a solution in couple A or in individual A would not necessarily be applied or be applicable in scenario C, for example. That is why we have the structure, but there are gaps, and the main gap is mediation and reconciliation in family law, especially in this context of assisted reproductive technologies and starting families using ARTs. In conclusion, what are the challenges? The challenges are the ambiguities in consent processes, and this has been a challenge not only in ARTs, but in the broader context of medical law. There seems to be issues of what constitutes consent, what constitute consent processes using Eurocentric and African perspective. There's a lack of clarity in defining legal parenthood versus cultural and religious definitions of parenthood, which differs. Therefore, if you look at, for example, the definition of what constitutes a parent in terms of the Act, it very much differs to my interpretation of what parenthood is in my African culture. Therefore, already to now settle a dispute, and for example, that arise in the African context, using the current system, using litigation will already give you problems. And then the inconsistencies and the issue of cultural sensitivities when the judges are interpreting the law, because now we are litigating, whereas if we opt for mediation, these issues may be covered. And then lastly, what would be the role of mediation in bridging these gaps? It will provide clarity where the law is silent. It will help parties navigate emotional and ethical issues. You would understand that the court never cannot, is not even empowered to assist parties to navigate emotional and ethical issues or moral issues or cultural issues. They do try, but we've seen in case law that the court is not a well-suited structure or a well-suited body to navigate those issues or to give guidance in these issues. They can give the guidance from a structural perspective, but not from a case-to-case perspective. It will also reduce the financial and the psychological burden of court battles in this case. You are all familiar with the case of AB versus Minister of Social Development. after the case went to the Constitutional Court, still AB, still there was no baby. She still couldn't navigate the legal issues in her case. So in a nutshell, because I can see that my time is up, the issues that I wanted us to look at is what would be the benefits of mediation in ARTs, because it is becoming extremely litigious. The benefits would be to enhance communication and trust between physicians and encourage patient-centered care. It will promote equitable outcomes. It will also increase access to ARTs by simplifying the dispute resolution. Some of the cases of couples or individuals who wants to access assisted reproductive technologies, they don't even end up materializing because of the court issues. Sometimes couples or individuals are unable to navigate or jump the legal hoops, which according to our research, we've seen that through mediation, it may offer that detour route that couples and individuals so desperately need in order to achieve their dream of conception and parenthood. And in conclusion, mediation is essential in the complex field of reproductive medicine. In fact, mediation is essential in the broader context of medical law, because we have seen time and time again that the litigation is not working for our healthcare system. And mediation offers the potential to transform ART dispute resolution. And in terms of the future direction, there is a need for policy development and mediator training specifically for this type of disputes, and the emphasis on respecting diversity here and protecting stakeholder rights. Thank you, colleagues. Thank you so much.
Thank you very much, Ms. Mtembo, for that presentation. I think what you've presented was very informative and very engaging. And I think the topic and the area of research is certainly something very interesting, but something that many of us have actually not given thought to as to how there's been so much of development and the controversial issues that arise in terms of artificial reproductive developments in our law and the implications of that. And thank you for sharing that with us, because I'm sure we've all benefited from the information and the presentation that you've given to us. I'd like to take this opportunity to just highlight some of the important points that you've raised. So you very nicely and very concisely set out the framework in terms of medical law itself, and where the problem actually arises in terms of the conflict, and that litigation itself is not always the best possible solution. That litigation provides a very conclusive outcome, whereas we are dealing with cultural diversity, you're dealing with people, you're dealing with the issue of religion, you're dealing with the issue of family outcomes. And that is why mediation is so critical to resolving this without, going through the litigious route that we have in our judicial system. You also provided very nicely what are the challenges and what are the benefits to mediation in this particular field. And you also highlighted the legal framework that we have. And I think that was very relevant to us. So I just want to, without going into too much other detail and going into unnecessary information that you already discussed with us, just want to say that it was a very comprehensive presentation, and well done to you. And I really do hope that you continue to research in this particular field, and I look forward to reading on your articles. And I hope that you've incited and encourage many of our attendees today to continue to research and also develop in this particular field. So thank you very much for that engagement with us. We're going to take questions and answers, but we're going to try and see if we can get Mrs. Esther on to do her presentation, and then we'll do a quick question and answer after her presentation. Nomfundo, thank you very much. Esther, can I check with you? How are you with your presentation? Are you able to present? Esther, we can't hear you. You need to unmute, number one. Okay. Colleagues, it's disappointing. I think Esther's got some serious technical challenges, and she was unable to also email her presentation to Dr. Stevens, so we can't assist her with that either. So I can't delay the program any longer because we've got an entire afternoon, and we do realize that you are all have other commitments as well. So on that note, I am now going to proceed with the question and answer session. I'm going to have to ask Dr. Stevens to please assist me with the with our colleagues who are in attending in person.
There are no open questions at the moment, and yeah, so I think we're good. The other delegates are communicating with Ms. Ntembo online.
Okay, I can see that, yeah. I can see it, and she has been, in fact, addressing those questions, so I'm not going to repeat that. And Dr. Stevens, are there any in-person questions for Dr. Ntembo as well as Dr. Estop? Sorry, you muted?
No, I'm saying to you that there are 2 questions from the in-person attendants.
Okay. If we can have those questions, please. We'll take the questions and then we'll ask our presenters to respond.
We can.
Thank you, Chair. My question is very brief, and it's directed to Dr. Esther. Thank you for a brilliant presentation, Doc. My question is around mediation as to what qualifications does one need in order to be a qualified mediator? So for now, that's the question that I have for you. Maybe it can be answered in also in conjunction with the ADR, if maybe there is a qualification for one to be an ADR/mediation. I think I'm clear on that. Thank you, Doctor.
Dr. Estop, do you want to respond?
Yes, I will respond.
Thank you.
Yes, I will respond. To be a mediator, family mediator, you have to do 40-hour intense mediation, family and board mediation course. If you are in the you then have to course that is psychology for mediators. And then there's another after that is someone of role plays, so that you have the experience as to how to interact with parties in front of you. Once you have done that, then you are accredited and you are a member of one of the associations, family associations. So it's quite a process to go through, but I think it's very fun.
Thank you, Dr. Estop.
Dr. Bernard, there are no more questions from the, okay, hold on, there is one question.
Thank you.
You highlighted that similar that content is one of the person who application for this ADR. So now he should be directed to mandate of subjects that to try and implement this ADR in trend. So now the question is, now this becomes compulsory. Then what about section 34 Constitution and justification for limitation of the rights of others to court? For some people may say, no, we don't want to take this. But the judge says, now we mandated everybody to go through this process first before approaching the court. Then, if we try and we'll see how we go about in just limitation of the rights of others.
Thank you for that question. Yes, these issues have been discussed quite a bit in the groups of family mediators, especially because there are issues with questions that came up is access to court and payment mediation fees. Who pays mediation fees? Is it the attorney? Is it the mediator itself? Is it on a pro bono basis? So that's some of the main questions. We've also, one of the things that come up is that has President overstepped his power to make the direction of this nature. But as it stands at the moment, it is there and one has to do it. So I think the media is set and as much as I'm saying, only in 10 it's a matter of time will come to the other provinces with insight. So yes, the question that you're asking is what about Section 34? Yes, that has been used. And there was a case taken to court, which they have moved now, the Constitutional Court in Europe. And I'm not quite sure what's happened to follow that, but these are the questions that companies and attorneys are asking. So yes, it is problematic, but it is what it is with case laws. The court cases are so many. Apparently, you can get support back for things like this in, I think it's 2052. So, because the role is so hard, this is why the mediation directive was one that made according to Judge President.
Thank you, Dr. Esther.
Dr. Bernard, another question. My apologies. There's another question from the in-person attendance.
Thank you.
Thank you very much. There's a comment particularly on the question that Dr. asked, as well as what's the best place that disputes that arise from income law. One we say, given the fact that because the courts, as Dr. mentioned, they are the blanket split on. So time to time they disregard geographical, cultural, and language considerations, which then becomes very difficult. One is that in the matter that is currently not held High Court, whereby it's a KZN matter that has to do with the region of KZN. And now that becomes a problem because the courts, many or the judges, they may well not be informed about the values of that particular community or that particular society. And then it may lead to a judgment that may serve the court itself, but not for its people. So same thing here when it comes to this law methods. It's not an easy one, but the fact that ADR is there, we believe that one time and one step ahead, it may try and bring those solutions. Thank you.
Thank you. Any further questions, Dr. Stevens? Last call.
Yeah, there's one more question, Dr. Bernard.
And I think this, Dr. Stevens, it will be the last question.
Yes, it will be the last question.
Thank you.
Get your opinion, particularly looking at the things that you covered now, like family mediation, the role of, course, making a directive of the deputy president, the former deputy president, making this directive where there must be these arguments, exploring programs. So, what kind of role can these two play thereafter? Made after the resolution we made in those control that the outcomes that have been made are preserved. So that because most of the times what happens is that those elements are so and then we go back home, then the matter start fighting problems and it goes back to court. So what role can these two mention preserve these outcomes?
Okay, so a lot of a difficult one to answer, but in terms of the two lines of their director, in the court proceedings, you have to fill in a form in order to specifically say that the parties are open to mediation or not open to mediation. So when a matter goes to mediation and it's resolved, parties are very happy and it starts again. I think that legislation will have to go because they've already done mediation, and I think second round mediation may not all or not all mediations are successful. But once that is done, then we for whatever needs to be seen to, but you'll have to go to the legislation as far as I know. And I am actually
There are no
Dr.
more
Esther?
questions. Oh, my
Yeah.
apologies. No, there is what. Do we have time for one more question from the in-person attendants?
We can take one final question.
One final question.
Okay, thank you very much. I'm not so sure whether it is a question or a comment, but taking from the response and the question about the directive from the Gauteng region, we seeks to incorporate the context in mediation several matters. But I should believe that I think I'm not trying to respond after down because I respond the speaker at the back to come to section 84 of the Constitution, but I think what the judge has said in section 170 of the Constitution that empowers courts come up with ways that will make the accessibility to justice. There is something called or the statement that we normally refer to say justice delayed is justice denied. And if you are to have matters that involve the best interest of the nation being prolonged in 2031, then there is no justice there. But my question is, like it's happening in other jurisdictions, where the government or the judiciary have a pool of mediators who are paid directly by the judiciary who are sitting in court, so as to ensure that people from vulnerable groups, from rural areas who also access to appoint mediators. Are we as a country pushing towards that direction to ensure that everyone who is supposed to follow this standard does it successfully without having finances to be able?
Thank you very much for that comment. Dr. Stevens, I think we now we've reached our time for this session to end. So I would just like to thank our presenters for their presentation. I'm sure everybody, again, found them very enlightening and informative. I'd also like to thank everybody who has posted questions on the chat and who have, in fact, asked questions and made comments for their active engagement and participation during the session. And then that brings us to the end of this particular session. And we will now then proceed to the next session, and I'll hand back to you. Thank you, Dr. Stevens.
Thank you, Dr. Bernard, and of course your presenters for your very insightful presentations and for chairing that particular session. I'm now going to hand over to Dr. Makutu to chair the next session, or the final session.
Dr. Stevens, and good afternoon once again to you colleagues, both in person and the colleagues that are online. Now we're moving to the world of commerce. We're moving to the world of consumer protection, and we're also moving to disputes that involve the Companies Act and how it is that the alternative dispute resolution landscape is being realized in these two arenas. So our first speaker, we are very privileged to have Mr. Lee Subrathi. Lee was appointed as a Consumer Goods and Services Ombudsman in July 2023. He's an admitted attorney and conveyancer by profession. He's well versed in the workings of alternative dispute resolution. Before being appointed as the Consumer Goods and Services Ombudsman, he spent 12 years working closely with the Credit Ombudsman, first as a senior legal advisor and then as the head of complaints and dispute resolution. So we have a wealth of experience here. He obtained his LLB degree from this very institution, the University of KwaZulu-Natal, in 2008. He also holds a master's degree from the University of Johannesburg, which he obtained in 2018. He's also an admitted attorney and a conveyancer, as I've mentioned, and a member of the International Golden Key Society. So it is my privilege to then hand over to you, Lee. Thank you.
Thank you so much, Chair. I hope everybody can hear me clearly. Just I need one thumbs up from somebody. Or even
Loud
from
and
yourself.
clear.
Okay, perfect. Firstly, let me start off by just greeting everybody, all the colleagues on the call. And let me also start off by saying that the privilege is mine to be obviously in the presence of such a wealth of knowledge. And in the short space and time that I have in the next 15 minutes, I think the objective and the task that I have is just to bring home the concept of an ombud within the South African space of consumer protection. And if anything, if we walk away today understanding what the ombuds do and how the ombuds fit within the sort of space of alternative dispute resolution, then I would have done my work, because these are always conversations that we understand are ongoing and we learn every day. And I'm looking forward to the engagement with the colleagues on the call, as well as any future sort of seminars that may happen. So my topic for today is the effectiveness of alternative dispute resolution within the consumer protection framework. I come from the Consumer Goods and Services Ombud, and essentially I'm going to explain a little bit of what an ombud is in the slides that are to come. But I just for a second just want to touch and to provide some sort of context on the overview of consumer protection within South Africa, because as an ombud, as an alternative dispute resolution body, we are a creature of statutes. We have our limitations in terms of the statute, and as a result, our powers and what we do comes from the legislation itself. Very briefly and quite speedily, we have the Consumer Protection Act, as we know, which is quite a predominant piece of legislation when it comes to consumer protection for goods and services. Now, if you are a consumer that consumes goods and services, the Act provides a list of rights and responsibilities, not only for yourself, but also for suppliers of goods and services. And if any person, individual or business provides goods and services as part of their business practice on its day-to-day activity, they are required to comply with the Act. And we have a plethora of legislation that we use when it comes to dispute resolution, which also includes other pieces of legislation like the Electronic Communications and Transactions Act, which regulates e-commerce transactions. We know e-commerce has been, how can I say, a buzzword since the advent of COVID, and for the last few years, we've seen e-commerce transactions rise phenomenally. And as a result, as ADR bodies, we were required to rise to the occasion, which means understanding the landscape, understanding things like marketplace sales, marketplace conduct, third-party services transacting online, because e-commerce essentially became a big part of what we do, especially with the lockdowns. And even since COVID, we see that traction hasn't reduced to the slightest. Now, when it comes to ombuds or alternative dispute resolution bodies within the framework of consumer protection, we turn to Section 82(6) of the Consumer Protection Act, which essentially is our foundational legislation. What the Consumer Protection Act provides, that where the regulator sees a need to accredit a body to resolve disputes, it can do so in terms of Section 82(6) of the Consumer Protection Act. And once it does this, once this piece of legislation, or rather once this code is accredited by the Minister and Department of Trade, Industry and Competition, then it is mandatory for all suppliers. And when I say all, I mean all. Doesn't matter whether you're a small business, whether you're a medium-sized business or a large conglomerate, you are required to not only comply with the CPA, but you are required to participate with the CJSI code, which means that you have to sign up with the Ombud so that you are part of the method of redress when it comes to consumer protection. Now, just to touch a little bit slightly on who is our customer, what is this act designed to do, who is it channeled towards? As we understand, I mean, by the very nature of the title, Consumer Protection Act, the act is not only there to protect the consumer, but also to create rights and responsibilities for suppliers so that they can know what their minimum obligations and requirements are. And very briefly, Section 2, read with Section 3 of the Consumer Protection Act, it provides for the mechanism of redress. If you look at Section 3.1, it says to provide for a consistent, accessible, and efficient system of consensual resolution of disputes arising from consumer transactions. And importantly, and provide for an accessible, consistent, harmonized, effective, and efficient system of redress for consumers. Now, having heard many of the presentations, and I've learned so much, learn every day in this position that I find myself in, we see terms like accessibility, consistency, fairness, efficiency. I guess the whole concept of an ADR is to provide cost-effective, or rather in terms of our services are free as an Ombud. But I mean, the essence and the principles are to provide cost-effective, efficient resolution. Because the type of consumer that we deal with, we're talking about your daily transactions. It could be buying a loaf of bread from your local retailer. It could be buying a microwave oven. It could be even buying a vehicle. Now, technically, these are always, or in many times, these are classified as fast-moving consumer goods. Now, we know that these sorts of consumers who are purchasing at such a high level with thousands of transactions happening every minute, they don't have the luxury of going and issuing a letter of demand, instructing an attorney to then start a process of litigation, is because, I mean, in terms of the costing versus the costing of the actual product, it doesn't really make practical sense for them, which is why the concept of an Ombud and an ADR process, it makes practical sense, is because what it does is that it creates a balance and a sort of an opportunity to have these complaints and these disputes met with efficiency, with timeliest resolution. And in essence, you'll see by my slides, it creates an environment, or an environment that's conducive to resolution. Because in the business of commerce, it is in the best interest of businesses to ensure that their products are safe, that their products are durable, and their products meet the requirements of Section 55 of the Consumer Protection Act, which means that when situations arise, and believe me, they will arise with the rise of consumerism and the rise of product evolution and the number of products that we have that creates for fair and sustainable competition, it's very likely that there are going to be instances where products become defective, where sometimes they become harmful. But that is why we have this piece of legislation that allows a consumer to exercise that right. And the ombud fits into that method of and mechanism of redress. And I'm going to explain how we fit and why we how we fit and what effect we have with regards to the hierarchy of other institutions that do make orders that are equivalent to that of the High Court. I mean, we all are consumers on this call. I mean, I don't think any one of us can say that we are not a consumer, is because we wear different hats professionally. But as family members, as heads of our homes, we also have the rights to goods that are of quality, have the rights to privacy, rights to choose, the rights of disclosure and information of certain types of products, the right to fair and honest dealing, the right to fair, just, and reasonable terms and conditions, and the right to fair value, good quality, safety of goods and services. So the concept of an ombud, I know many times I meet many people when I mention consumer goods and services ombud, I'm normally met with a raised eyebrow or a sense of confusion. So I think what's important for this call is that we just take 1 minute just to spend on the concept of an ombud, which we understand is it's not a new concept. It's been around for quite some time. It's a Swedish concept that was developed primarily for government seats or government institutions to provide a method of sort of impartial oversight to resolve disputes within government, be it maladministration, corruption, injustice, whatever it may be. And over time, the concept of an ombud has evolved to apply to every type of situation wherever there is conflict. Application in the world of consumerism as we see it today, the ombudsman is an independent, impartial body that is established to address conflict and to do it in a fair, impartial, and independent manner. In fact, it provides an alternative to formal legal action, offering a more accessible method of redress. Now, there's a common term that we often use when it comes to mediation and how we address the situations, and that is one of framing. Now, just to paint a bit of a picture, remember, when a consumer reaches the shores of the ombud, they're already in a sense of panic, they're in a sense of frustration, they're in a sense whereby they are in quite a strong position where they believe that whatever the position that they are in is the correct position. They have a guaranteed right to a refund or a replacement or an exchange, and nobody can tell them anything that will change that mindset. And so, as you would understand, that when we meet a consumer at inception of a resolution, of a complaint, we have to almost sort of peel away the complaint like you would with an onion. And we often refer to an onion. I know in my training as a mediator, we always go back to the concept of an onion, because like with an onion has many, many layers, you almost have to start to peel one layer at a time, which means, number one, assuring the consumer or the supplier could be that we are here to assist them, that we are here to be an impartial sort of person. We are not here to take any sides, but we are here to make the parties understand what their rights are, to understand their fears, to understand their positions, their interests, their wants, and their needs, and slowly bring them to a place where they can start to look at what resolution looks like. Now, in the concept of mediation, or our experience as we see it at the Office of the CGSO, we often are placed in a position where we have to define and interpret what conflict is and the way it's presented to us by the consumer or even the supplier when they send us a response to the complaint. And this involves using language and communication strategies and techniques to influence how these individuals or these companies perceive and understand what the conflict is, what the situation is, and it is our job to influence them through the evidence, through the facts, and through the questions, so that they can look at what does possible resolution look like. Many a times you would ask them, do you foresee a future relationship with the supplier? What does this future relationship look like? Now, this is important, like I mentioned a few minutes ago, is because when it comes to business transactions and when it comes to commerce, well, businesses are not in the business of losing customers. And you will find many a times that suppliers will come to the party as opposed to going through a full-blown investigation. They will meet the consumer in terms of their complaints and frustrations. They will offer without compromise a replacement or a refund without them having, or basically without a recommendation for them to do so. And what this shows us is that it's having the parties placed in a position where they are being heard. They are being given the opportunity to respond. They've been given the opportunity to have their matter heard. And once that happens, then we open the doors for communication, which in any situation we've seen can only bring the parties to a better place than they were before approaching the ombud. Like with any process, the consumer is required to first approach the supplier before approaching the ombud to give them an opportunity to resolve it within 15 business days. And where that initial attempt fails, then they may access the ombuds, who then have 60 business days within which to resolve the complaint. But we endeavor to resolve it much sooner than that, as our current average closure rate is around 41 days, which we take pride in, is because we are continuously trying to ensure that time limits are reduced to lessen the frustration of the consumer. At a very high level in South Africa currently, as part of the Consumer Protection Act, we have 2 accredited ombuds. That is the Consumer Goods and Services Ombud, which is our offices, which came into effect in 2015. Before it was at that point it was accredited. 3 years prior to 2015, it was a voluntary code that was then accredited by the minister. And then we have a sort of a sister ombud known as the Motor Industry Ombud, commonly referred to as MIOSA, which was accredited in 2014. Chair, I am mindful of time, so if I could just have a few more minutes just to sort of round up. But yeah, time is not on our side when it comes to this sort of discussions. When it comes to ombud schemes, we are not the only ombud that exists in South Africa. We have other ombuds, also known as financial ombud schemes, that recently, in the last year or so, they've come together. We have 4 prominent ombuds previously known as a credit ombud, the banking ombud, the long and short-term ombuds that have recently come together and followed international global practice to unify the ombud so that the consumers have a central place within which to have their complaints resolved. A key distinction, though, while the financial ombuds or the national financial ombuds are geared up and they are empowered to make binding outcomes or rulings as they use it, as the CGSO, as an accredited ADR body, we do not make rulings, but we make recommendations. And you'll see the recommendations falls within the sort of evaluative form of mediation. As we know, with mediation, we get different forms. We get transformative mediation, which looks at relationships, and as I understand, is used primarily in family law disputes. We have facilitative mediation, which the mediation is there simply to allow the parties to reach an agreement. And we have evaluative mediation, which is what we do, because we use the CPA, the Constitution, other pieces of legislation to test the complaint against, to make sure that even if the parties reach an agreement, the consumer is not done in. They are not given less rights. We always ensure that they are given the minimum what they deserve, and we ensure that by having the evaluative form of mediation, we ensure that what the supplier is proposing meets the test of the CPA, if not better, if that is what they are willing to do. I'm going to fast forward just a little because this is a slide that I didn't want to stop at, because this in essence brings into summary the entire mediation process. And I'm sure I'm met with a few smiles when you look at this photo. You'll see on the left, on my left rather, you have the green man, which is the CGSO, which is essentially coordinating the dispute between 2 parties. The party on the right may have a dispute regarding a product that they purchased, the supplier on the opposite end, and our job is to manage that process to ensure that the CPA is executed in a way that's fair and transparent. But when consumer and supplier initially starts off the relationship, if a matter does come to the ombud, it's very unlikely that the matter has not been resolved. So we have a Mr. America versus Iron Man situation. The parties are at odds with one another. They are angry with one another. There's no chance of resolution at this point. But our vision is to make them essentially end up as the last picture that you see, for them to come together so that they can have a future relationship, because the last thing that a business wants is to lose a customer, and the last thing that a consumer wants is to lose confidence and trust in the supplier who they ultimately trust to provide them services that are free of defects and obviously of durable and quality. Now, in any mediation process, and the slides will be shared with you, we know that it is our job as mediators, as ombuds, as ADR bodies to move parties from positions whereby they do not want to budge. They have basically a concrete sort of view of the situation. They believe that their answer is correct or their perception is the correct one. And it's our job to take into account the stuff that you don't see that falls below the line. Things like their needs, their interests, their fears, their concerns. Things like how far have you come in trying to resolve this? Yes, you bought a piece of equipment, you haven't had any business for the last 6 months. What impact has this had on you financially? What can the supplier do to meet that demand? And it's our position to try and ensure that they come to a place where they're able to compromise and reach a zone of potential agreement. And some key concepts in summary, Chair, I want to close up on. I think there's beauty in informality when it comes to ombuds. And I know one of the presenters says that even though it's informal, when the parties do reach an agreement, then it becomes seriously formal in the sense that one can take action. But in order to get the parties there, we find that in the ombud process, the sense of informality is a beautiful concept. It's less adversarial. It allows us to ask the difficult questions and also to address the sort of situation like empathy, emotions, and that sort of nuances that often play when it comes to dispute resolution. It's by consent, impartiality, independence, fairness, the ability to walk in. You can have walk-in or digital. One of our strategic themes is providing access and quality outcomes, which means that we want to provide access to the marginalized and most remote communities is because consumers, they are entitled to that right. And in terms of the methods that we use, funny enough, we very seldom has face-to-face mediations where we can sit the parties in one room. What we find is that working with the parties independently or in private meetings along the process helps us to manage emotions, help us to manage expectations, and also propose solutions that works for both sides or both parts of both parties that are party to the dispute. We use mechanisms like reflecting, paraphrasing, summarizing, and effective inquiry to flesh out commonality between the parties. And importantly, best alternative to negotiated agreement. We call this a reality check. Often consumers don't understand that if they don't sort of come to the party whereby they can understand, because a consumer may very well know what they want, but what they want may not necessarily be what the CPA can give them. Consumers easily come to us and in some instances claim R1 billion, 500 million for pain and inconvenience. As the ombud, we don't have the jurisdiction for delictual damages, for pain and suffering. But what we do is that we suggest to the consumer, this is what the act can do, this is what you can expect. And it's almost bringing into effect the reality check for them to understand that if you have to go the legal route, you can easily ignore or reject our recommendation as the ombud. But if you were to instruct an attorney and go the litigation route, this is what you could possibly be facing. And many times that sort of brings consumers and suppliers into the reality check phase, and they often come to the party and suggest solutions with the aim of reaching an agreement. I've put some extra slides in here just to show you in terms of hierarchy where the ombud sits. We are fortunately at the bottom of the food chain, which means less formality, less red tape. Of course, we have the Consumer Goods and Services Industry Code that we recently had to comment on because it was published for comment because it was a 5-year revision of the previous code, of the current code. But essentially, even though we have the code that gives us the ability to exist, from an escalation point of view, we are the point that you would go to once your supplier cannot assist you or if you're unhappy with that outcome. So we are at that point whereby we can manage expectations and almost prepare the consumer and the supplier should the matter eventually go to the National Consumer Commission, who we report to, or the National Consumer Tribunal, and ultimately a High Court. That, in essence, Chair, is my presentation. And if there's any questions, I'll be happy to take them now, and I'm happy to also share this with you so that you can disseminate to the rest of the court. Thank you so much for the time and for the opportunity.
Thank you very, very much for that presentation. It was very clear, it was very concise, and I think it gave us all some additional information about the ombuds and the ability to deal with relatively minor complaints so that products and services remain at the required standard. They're safe, they're durable, they're not defective. We really appreciate that. We also appreciate knowing that the Ombudsman is an impartial body that is sitting there to oversee what is going on and to resolve disputes. It's also heartening to understand that you engage in the evaluative mediation, which guarantees that consumers will obtain a settlement that at least guarantees them their minimum rights that they deserve. So thank you very much for that. And we will take questions after the second presentation. So I'm going to move on to the next presentation. Our next speaker is Mr. Masudi Mpeta. He's a qualified attorney of the High Court of South Africa, and he currently serves on the legal committee, on the legal compliance and company secretariat as a specialist at the company's tribunal. He brings extensive experience in corporate governance, statutory compliance, and litigation in both the High Court and the lower courts, the Magistrates Court. At the tribunal, he ensures adherence to the Companies Act of 2008, and he also supports the efficient resolution of company-related disputes. He represents the tribunal in public engagements, including radio interviews and national outreach events such as annual business empowerment luncheons and so on. So we are very grateful that he has taken the time out of his schedule and is here to impart some very necessary and relevant information in our colloquium. So thank you very much. I hand over to you, Mr. Mpeta.
Thank you, Prof. I hope my screen is visible to everyone.
The screen is visible. Thank you.
Thank you so much, Prof. Prof, my presentation will, firstly, I'd just like to greet everyone on the platform and everyone in the physical meeting, and also like to thank UKZN for the opportunity to grant the tribunal opportunity to present at the seminar. So I'll just touch base on 4 points on my presentation. It will be my introduction, the ADR through the Companies Act of 2008. There's also the extended mandate for ADR through the Companies Amendment Act of 2024, and just outline the ADR process for the tribunal. So the first point is the tribunal is founded through the Companies Act. It's established through Section 193 of the Companies Act, just outlining the issue of jurisdiction throughout the Republic, that it exercises its function through the Act, that it's a statutory body. Then one of the main or 2 or 3 functions, it mainly has 3 functions, but the 2 major functions that it has is 2-part. There's the element of adjudication, where we adjudicate in relation to any application that may be made in terms of the Act, and then the tribunal can make an order in regard of that application through what has been presented. Then there's a second element which I'm also going to be talking to, which is the second element is that it assists in resolutions of dispute through ADR as contemplated in Part C of the Act. So the first part, which I'm not going to be really dwelling on today, is the adjudication. The adjudication, it deals with different types of matters, whether it's compliance notice, exemptions, etc., through the Act. But what we are going to be presenting on today is the second element, the ADR process. So our ADR process finds its expression through Section 195 of the Companies Act, which then mandates the tribunal through Section 195(1)(b) to assist in resolutions of disputes. That resolution of disputes then is linked with Section 166 of the Companies Act, which talks to the issue of ADR. But in this part, it talks to ADR as a voluntary process that parties engage when they come to the tribunal. Then there's also this second element of the ADR, which is linked to the tribunal, which comes through Section 156 of the Act, where it talks about what type of matters that it can address to assist. So it also talks about alternative procedures for addressing complaints in securing of rights, whether you're an interested party, etc., etc. So then the tribunal kicks in when we can also resolve those parts. Then there's a second element to that. If you look at Section 167 of the tribunal, where it talks about the dispute resolution that may result in a consent order. So if the ADR process doesn't collapse at the ADR process, the tribunal has powers through the Act to provide the parties in that arbitration with the consent order. So that consent order is the resolution of the process. And if there's no dispute between the parties, that consent order can then be made a court order. Then if we move from that's the old process as it is today. But alternatively, what we are looking at, there was a government gazette that proclaimed the amendments of the Act late last year, 2024. But prior to that, there was another gazette with extended mandate for the tribunal through Section 166, which is amended 166, which then gives powers to the tribunal to be the sole tribunal to resolve company disputes. Because what you find at the moment is majority of parties, when it comes to company disputes, they might resort to going to the other arbitrational bodies. So what this amendment now looks to do is that all company-related disputes for ADR purposes must be channeled through the tribunal. So it's one of the issues that we are waiting for enactment through the department, because we are an entity under the Department of Trade and Industry and Competition. So it's one of the engagements that we've been working on to say, when this comes in, it needs to be channeled through what we are saying, that the Act now says that the tribunal must resolve those disputes. Then if you look at also the gazette from last year regarding the Companies Amendment Act, regarding arbitration, arbitration ADR, there's a section in the Act which has been amended, which is Section 195(1)(d), which now also gives the tribunal which works with one of our sister entities, the BBE Commission, that the tribunal can the BBE Commission can refer matters to the tribunal for ADR purposes, whether it's conciliation, mediation, arbitration, but also including the amended 166. We're still waiting for the enactment of that act or that section, together with the regulations, which will talk on how will that process be referred to the tribunal. So there's that process that we are trying to work with the department and the BE Commission. How is that process going to be streamlined? Then just to finalize my presentation, our ADR process from the tribunal is quite flexible, but there's a form, for example, that the Office of the Registrar will give you to fill in. It's a CTR 132.2 form. Then there's also ADR agreement that we always allow our parties to also engage in. Then we also have mediation rules and arbitration rules, which we just put in place that, especially for issue of timeline for filing and etc., that this can be followed. But our process is cost effective, it's free, and it's speedily. When we talk about speedily, based on our current APP, our ADR process, we work towards providing a decision within a period of 30 days. So it's one of the processes that we are trying to also get out in public. There were colleagues earlier on who spoke about the High Court directive regarding mediation and arbitration. And it's one of the spaces our judge, our chairperson, Judge Dennis Davis, he's been engaging with DJP on these issues to say, if there are any matters that are on the court roll that are clogging up the court roll, especially commercial company law matters, those matters can be referred to the tribunal for speedily mediation, all of those mechanisms. Then also our processes are flexible, that as much as it's flexible, there's an element of trying to get parties together into resolving the issue instead of avoiding the issue of litigation, which can be acrimonious and be problematic for companies. So that's mainly what we try to do with our ADR processes, and our members, which are appointed through the ministry, are quite experienced in the issue of mediation, arbitration, and the whole concept of ADR. And we encourage people that they should try and look at or explore our services, which are readily available, whether it's through our website. We've got a case management system that tries to channel this type of applications, but even with the Office of the Registry, we do accept calls, etc. Prof, thank you so much. That concludes my presentation.
Thank you so much, Mr. Mpeta, and we are very grateful for the information that we've received from you, and also that it is also reinforcing the various messages, core message that even in the company's tribunal, it is cost effective. It results in less time. Resolution within 30 days is clearly something to be aspired to, and it will hopefully, once the message that you are actively trying to get out there is received, result in more referrals to your tribunal and more efficient resolution of disputes. Like other processes, you have highlighted that though there are guardrails with regard to filing and so on and time limits, the process itself is flexible. And the goal is to obviously resolve the dispute and ensure that the case management system that you have highlighted is in place, results in dispute resolution that is in line with what the parties, the various parties would prefer. So thank you very much for that intervention. And this then is our time to have a question and answer session. So I will take any comments, any questions that are coming either here in person or from our online participants. There's an online question, I am told. So the question from Andisa Potwana says this. He appreciates very much the presentation,
And the question is this: if conciliation or mediation fails, what options would an aggrieved party have? If the dispute can be referred to the tribunal, or if the dispute can be referred to the tribunal for adjudication, would the same person or persons who conducted the conciliation or mediation participate in the adjudication of the dispute? I'm going to assume that this question is for you, Mr. Mbit. You can go ahead and respond.
Okay. So in terms of our process, our case management process or allocation goes through the chairperson of the tribunal. So in a case where we go through the conciliation and arbitration process and it collapses, we do have a process where the tribunal does issue a fail certificate for that process. Then alternatively, on the other part, if the matter goes on adjudication, there's also an allocation process that happens. So I'm pretty not sure on how the registrar and the chairperson do allocation, whether the same person who tried to reconcile the member would also be appointed as the let's say the adjudicator to make a decision, because our adjudication process and our ADR process is quite separate. But then in that situation, then if that decision is then made on adjudication and there's a party that's not happy with that decision, we always encourage our clients to take that decision to the High Court for review. So there's those two elements within our process. Thank you, Prof.
Thank you very much. Do we have any other questions? We have another We have another two questions.
Thank you. Mr. Penta, given that the tribunal is free and cost effective, the presumption is that then many people many people then prefer the tribunal to settle their dispute. So how do you ensure that in a space of 30 days, order of judgment has been handed down? The second question is, we know the notion is in our society that just because something is free, that might not give desirable outcomes. How then does the company's tribunal ensure that it gives the best to the quote litigant and quote? Thanks.
So maybe I should, because it was a two-part question, allow you, Mr. Mbita, to give your response before we get to the next participant's questions.
Prof, before I respond, I just lost the second part of the question from Mr. Potwana. Can you just repeat that for me? Sorry.
Thank you so much, and I apologize for that. The question was, given that the tribunal is voluntary and cost effective, and the notion of the public is that if something is free, let me put it like that, then the outcomes are not as those that were expected. Then how do you ensure then as the company's tribunal that that notion is not in the public, but the company's tribunal does the best work? Thank you.
Okay. The first part of the question, the 30 days process. So what we have done as the tribunal to try and meet the rigorous timelines that we have is through the Office of the Registrar. There are timelines that they strictly do follow on the turnaround times, whether it's the issue of filing, whether it's the issue of set down, whether it's the issue. And if you look, I mean, the tribunal this year, it's celebrating its 11th, if it's not 12th year. And if you look at our targets or our turnaround times, the majority of the cases, especially when it comes to ADR, we always meet those targets. Our biggest struggle is the issue when it comes to complex adjudication matters, where we sometimes overlap on our turnaround times. I think at the moment it's at 25 days, if I'm not mistaken, whether it's opposed or unopposed. That's where I think even the Office of the Registrar is struggling, because some of the matters that we have on the adjudication side can be very, very, very complex, that it needs extension of time. Then the second part of the question, the issue of our decisions and the nature of them. What we have been doing, especially in the current term with the current cohort of members, is through the Office of the Registrar and the Office of the Chairperson through Judge Dennis Davis. When it comes to issues of mediation and issues of arbitration, the ADR process, there's been a push to try and train our members as effectively as we are, to the point that even now, with the enactment or the process that we are waiting now to say that we're waiting for the department to enact the amended 166 to give us those powers, where the tribunal is going to be the one that solely has that function. The judge has been motivating the department that they could maybe add a cohort of more experienced former judges or former what you call senior counsel to be part of the panel, especially when now there's this move that, especially with the movement that the judge is having, that he's trying to have much more complex, difficult arbitrations that the tribunal can handle. But in order for us to move in that space or engage with the big law firms that do these complex commercial company law cases or arbitrations, is that we also trying to strongly motivate that our pool is enriched by those type of people. And even one of the issues that I'm raising, the issue of training. For example, this year, our members were trained by the former Judge Nugent, who was active and involved in the process of the tribunal, trying to refine the processes when it comes to decision-making, interpretation of the act, and how the decisions should come out for the tribunal, trying to train those members in that space of decision writing, the issues of the processes for ADR, etc., and also refining our arbitration rules and mediation rules and all of those things. Thank you, Prof.
Thank you. We'll move to the next question. Thank you.
Thank you. I think this is directed to both Mr. Beta as well as Mr. Subrathi. Not all attorneys get excited to litigate. Now, in order to ensure that a client who approaches an attorney receives this fee as well as go through this expeditious process, do you, both Mr. Subrathi and Mr. Beta, that you allow legal representation when you deal with these matters? As I say, not all attorneys they want to go through those court processes, which may take quite some time to get matters resolved. So, yeah, that's my question to both of you. Thank you.
Thank you very much. Mr. Subrathi, what say you?
Thank you so much for the question. In fact, this particular subject is actually catered for in the Consumer Goods and Services Industry Code. And I think the test is that if a consumer with a complaint has actively or has started the litigation process, then they would be excluded from using the ombud process. And to answer your question, that unless one has to be assisted by an attorney due to some limitation, the act or the code actually excludes consumers that are represented or have a legal representation. So the whole purpose of the Consumer Goods and Services Industry Code, as well as this ADR process, is to cater for consumers that cannot afford, the legal representation, but also to cater for those who can. So if you have not started the legal process, if you do not have an attorney, if you have not started, the letters of demand or sort of engagement process, then you are more than welcome to approach the Ombud. But if you are represented by an attorney, in order for you to continue with the ADR process, unfortunately, you are going to have to do that on your own. You cannot be represented by an attorney. It is set in the code, and that is how the process is currently being applied when it comes to legal representation. Thank you so much, Chair.
Thank you. Mr. Mpeta.
Thank you, Prof, for the question. On the tribunal side, we don't really discriminate on representation. For example, we are housed at the DTI campus. For example, with the Office of the Registrar, whether you are a layman on the street and you come, the staff at the registrar's office are able to assist whether you walk in, whether it's through the phone or through the case management system. Even if the issue that if now you have a legal representation to do that application or the process or argue your case when it goes to adjudication or through the ADR process, we invite all parties and we don't have a problem with representation, whether it's a lay person, whether it's a legal person, whether you've got your own legal representation. But on our side as the tribunal, our fees, we don't take fees. It's the issue of the cost-effective part. But you will have to now, if let's say a member or a public member comes in, they'll have to bear the brunt of those legal fees themselves. But if they want to do that application alone or without representation, there are people at the office to guide you when you fill in your forms, to do affidavits, etc. So we are on that part. Thank you, Prof.
Thank you very much, Dr. Stevens. Thank you.
Thank you, Dr. Makutu, and to Mr. Subrati and Mr. Mpeta for your presentations. We appreciate the insight that you've given us, and also for our questions for those gentlemen or those our in-person attendees who posed the particular questions. It just shows that people are still awake. But thank you, ladies and gentlemen. We're coming now to the end of our program. I want to just call on Professor Ernest Tenzer from the School of Law to just give us the closing remarks. Thank you, Prof.
Good afternoon, colleagues. Mine is simple, it's just to close and to thank all the presenters and all of us that came in here and those who joined us online. I was quite equipped, encouraged by the presenters and the views that they presented on us, in particular the use of ADR, and some of us were not very aware of this. But I've got 2 points that I want to take on that. If the system, the justice system here is serious about this, there must be uniformity, maybe in the form of legislation or what, because there might be a form of discrimination, because some people who have money, they will say, oh no, we don't want to go through this process of ADR, but it's for those who do not have money. So we want to create a uniformity, because to avoid the system to say now that law is available to certain kinds of people, not those who do have money. And again, in that issue of Section 34 and Section 36 of the Constitution, I heard my colleague when she was saying that there is a bill or a draft paper. Things stand. Section 36 says if there's limitation of right, it must be in terms of the law of general application. So now we don't have law of general application that specifically deal with this matter. So, but I'm happy that she did touch on the issue that there's a bill or there's a draft paper that might be a law of general application if it is legislation. Otherwise, we are very happy that this system will try and alleviate the backlog when it comes to cases that come before the court. So that issue of Justin Mlambo and his proposal to say that all calls, if possible, in particular in Gauteng, they must go via this process of ADR. It is commended because we know that there's a long list, there's a long queue of cases that come before the court. If we have this system on the other hand, and then they insist that civil cases must go first via ADR, then I'm sure it will resolve this backlog of cases in the course. Otherwise, we thank everybody that attended us and knows that joined us on. Thank you.
Thank you, Prof. Tinza. I now want to call on Prof. Subramanian. Started off with welcoming you to this seminar. We now ask of him to just do a brief vote of thanks. Thank you, Prof. Subramanian.
Thank you, Dr. Stevens. Ladies and gentlemen, I will deliver the vote of thanks on behalf of my colleague, Dr. Tui, who unfortunately could not be present here this afternoon. I must note that at our peak this morning and afternoon, we had about 120 people online watching and listening to the proceedings. And that's besides us who are here. It's also streamed live on YouTube, and I'm sure those who could not actually watch it live will then also watch these presentations later on YouTube. So as we bring this insightful and thought-provoking ADR seminar to a close, it's my privilege to extend a sincere vote of thanks on behalf of the School of Law at the University of KwaZulu-Natal. First and foremost, I would like to express our heartfelt gratitude to the Deputy Vice-Chancellor of the College of Law and Management Studies, Professor Kalema, for his unwavering support and commitment to fostering research and innovation within our college. We're equally grateful to our Dean and Head of the School of Law, Professor Freddie Mnyongani, whose leadership and encouragement continue to inspire a culture of academic excellence and engagement. To our public relations team, we extend special thanks to Ms. Hazel Langer, Ms. Tandiwa Jumo, and Ms. Hopulang Imyeni, whose professionalism and attention to detail ensured that the event was effectively publicized and that our communications reflected the high standard we set for this gathering and our institution. We also wish to acknowledge the tireless work of our administrative team in the School of Law, Ms. Razia Ahmed, Ms. Fikile Nkwenazi, and especially Ms. Carol Nasaya, who behind the scenes coordination, logistical support, and organizational acumen were indispensable in ensuring that all aspects of this seminar ran seamlessly. A special thank you must also go to our colleagues from ICS, Mr. San and Mr. Kurt, whose technical support was the backbone of today's hybrid seminar. Your efforts ensured that all our participants, both in person and online, could engage meaningfully and without disruption. We thank you for that. To my colleagues in the School of Law, I extend a heartfelt thanks for your collegiality and support in promoting today's seminar. In particular, I wish to acknowledge the members of the ADR Research Interest Group, whose commitment to the development and visibility of alternative dispute resolution as an academic and practical field continues to drive the growth of this important area of law within our institution. It would be remiss of me not to make special mention of Dr. Claudinia Stevens, who was the driving force behind the initial vision for the seminar. Dr. Stevens, thank you for your leadership and for laying the foundation for what we hope will become a lasting tradition. I also wish to sincerely thank Dr. Lindiwe Makutu, who graciously joined the organizing team and played a vital role in coordinating today's program with dedication and professionalism. To our distinguished speakers and chairs of each session, thank you for sharing your expertise and for advancing the discourse on ADR and ODR in our region and beyond. Your contributions today have helped us integrate pressing issues and reimagine the future of dispute resolution in Africa. To our delegates and attendees, both in person and online, we thank you for your participation, your engagement, and your presence. It is your interest and enthusiasm that bring meaning and momentum to forums such as this. In light of today's success and the growing importance of ADR in both legal practice and education, we are pleased to announce our intention to hold this ADR seminar annually. We look forward to building on this foundation and to engaging with you again in the near future as we collectively work to advance access to justice through innovative and collaborative dispute resolution mechanisms. Thank you once again, and may you all travel safely. And now, ladies and gentlemen, I'll give the last word to my colleague, Dr. Stevens. Thank you very much.
Thank you, Prof. Subramanian. Indeed, it's been, since the journey started last year, it's been a lot of thinking, engaging, and we appreciate everyone's input. To our online attendees, we thank you for your patience. Of course, to our in-person attendees, we thank you as well for our patience and for participating in this discussion. And I'm glad that Prof has mentioned that we are going to continue with this and not just leave it at this discussion. And that we are going to focus on, or maybe that we are going to look into having this seminar annually. And of course, that means we're putting our caps on, our thinking caps on, to look at what can we do, how can we better the current processes, etc. And ultimately, ladies and gentlemen, I started off by referring to Agenda 2063, and of course, the African Continental Free Trade Area. Ultimately, how can we use ADR to ensure the Africa that we want? Thank you once again for your attendance. For our in-person attendees, please join us for lunch in Suite C. Otherwise, thank you so much.